2nd, March of 2022, Eric Richins is found dead in his beautiful Utah home. 5 times the lethal dose of fentanyl in his system. His wife, Kouri, well, she writes a children's book about grief, goes on to local TV to promote it, plays the grieving widow. Then investigators come knocking, and now she's sitting in a jail cell charged with murder. But here's the problem for prosecutors. The guy who supposedly sold the fentanyl, he now says he never sold fentanyl. Says he was detoxing when he talked to the cops and doesn't remember what he told them. Today, Kouri Richins is in court fighting to throw out the evidence against her. Her phone, her statements, a jailhouse letter, also known as the walk the dog letter, which prosecutors are calling witness tampering. They're looking to get rid of all of it. Can the state prove that she got the fentanyl? Or is this a case to about blow up before it even gets to trial? Let's get into it here on Defense Diaries. Good morning, beautiful humans, and welcome to Defense Diaries podcast. I'm your host, Bob Mata, and as always, I am joined by my beautiful and brilliant co-host who is no longer lagging, Allie. What's up, girl?
Hey, babe. Hey, all. I have to say, the intro, I had to turn my volume all the way down. It was blowing my ears out.
Really?
Whatever settings I reset, I don't know what's going on.
It's going to take some getting used to. Like hitting live and being on screen like immediately is just not what I'm used to. It's like I'm like, hello? Because I don't know if there's like you hit the button and there's, it's got to go from StreamYard to YouTube. I don't know. And we are going to shorten. Look, we love our theme song. It's an original. Allie's insistent that 1 minute and 15 seconds is too damn long. So we're going to have to trim it. We'll pick out the best parts because we love that theme song. We don't ever want to lose that. I think it's part of the DNA of our channel for sure, but we'll figure it out. We're going to be doing these like cold openings from now on because it's what the tubes demand. So plus, if people are scrolling by and they just see that video, they're gonna keep moving. So
I say we need like 15-second intro. Someone has to make us something super cool.
Yeah, using our song though. Yeah, we're definitely keeping the song. We're definitely keeping the song. It was close to flawless. I had a couple of flubs there, but what are you gonna do? But thanks. Yeah, I know. That's the new. If you guys weren't, oh my God, there's Brooklyn. I've missed you so much. I kept wondering, I'm like, where in the hell is Brooklyn? I haven't
I know
seen her
where
in forever.
Cody in Tennessee's been.
In Tennessee,
Deep
listening to
into some
Gacy.
buried, yes.
All right, so surprise! We are here today for the 2 days of Kouri Richins hearings. These are going to be some bangers. Now, we've done a lot of coverage on Kouri Richins. We've got plenty of stuff you can go back and watch if you're not familiar with the case at all. This is kind of like the entire case is kind of floating in the ether for the state. If some of these motions to suppress are successful, they are serious blows to the state's case, especially the fentanyl dude. Like the fentanyl guy who is recanting what he said in terms of being the guy who sold fentanyl, not to Kouri directly, but to her go-between, is now saying that he was in detox, that he was all fucked up, that this wasn't something that he really did, and he was just saying shit to stay out of trouble with the guy. So we'll see. I mean,
look, I gotta believe him. He's saying it pre-trial,
right.
And
I
it's
mean, that
hard.
is your
It's
preference, right? I
hard
mean,
to come back from that. I had a case where I was hired by a witness who was being charged, and I told the ADA that, look, he's saying that he didn't mean, like, the cops pressured him, and if you put him up there, it's to lie. And they were like, "Oh, no, no, he told the truth." There was like, I was like, he doesn't know this person. Like, he has no connection to this person that you're having him testify against. They did not care. So it is hard. There is a lot of pressure to undo what was once said. Threats, you know, pressure, all the things. So, some people look at it as bullshit when someone recants, and, depending on the time, the place, the how, it to me, it's powerful. And in this situation, knowing very little, knowing literally just the words you just spoke.
yeah, and look, it is way, way easier to sell a recantation, as Ali said, pre-trial than as opposed to a guy changing his story 15 years later.
Right.
It just is. It just is. And it's like we're seeing that issue. We saw that issue in Zach Adams in his post-conviction hearing. We've got their star witness now coming forward and saying, yeah, that was all bullshit. Which I believe wholeheartedly. However, getting a judge to believe it is a different story. But I've got a lot of faith in that judge, for reasons unknown. I think I just like his demeanor on the bench, and I thought he was fair in his rulings. And I don't ask for much from a judge other than to be fair and to follow the law.
But that walk the dog letter, that's the thing, you know? It's like, no one's buying her story of she was writing a fake play or story or book or whatever in jail. It's just, you know, I'm not buying it.
Yeah, so the way that the Richins hearings are happening, they're going to be on delay, as they're prone to do in Utah and Idaho. It seems like they do. They
I
do
thought
the
we set it for 10:45 so we could be sure before we started that it was actually streaming.
There is no being sure when a judge is saying we're delaying it for X amount of time. Like
I know, but you know how you're sure? When you
wow,
see it, when it
I've got
starts
it up here.
playing. That's
Like
what I'm saying. We should have.
we need some time to warm the people up, babe.
All right, so
I
then warm
know.
them up about giving them some more details and a general overview of Richins.
Okay, so essentially what we're going to be looking at today, again, the cold intro gives you the overview of the case, like the 30,000-foot view. Okay, so Eric, back in March of 2022, he dies of a fentanyl overdose. Okay, he's found dead. They do a tox screen. They find a huge amount of fentanyl in his system. It turns out that the night prior to him passing away, Kouri had made a couple of delicious Moscow mules. The state's theory is she dosed the hell out of him with fentanyl, which she had secured through a go-between. And this, in the state's estimation, this was the second time that she had tried to kill him. The
But
first
wasn't it
time,
something different the first time, not
yes,
fentanyl?
she made him a sandwich.
What, with fentanyl or with a different, do
I
we
think
think it was?
it was with fentanyl, but she
Oh,
didn't put enough in, is what the
oh,
state's theory is. So she made him this delicious sandwich for lunch. She says, "Oh, here, honey, I made you this beautiful turkey sandwich.
and he got
Eat
sick
this
as
at
a
lunch."
dog,
Sick
right?
as a dog, comes home. He's laying in bed, it feels like shit, survives it, but he starts thinking did my fucking wife just try to kill me?
Now, how do we know that?
Because it's come out like that came out. He told that to multiple friends,
That he thought after
and
he ate this sandwich that she tried to like, literally, did he use the word kill, poison, make me sick?
I think I don't know. Like, don't ask me a bunch of
Sorry.
detailed questions, dude. Do you know? Like, you were on the
I
live with me. Can I
I
start
don't.
grilling you? Okay, calm down.
I didn't I didn't know that you weren't gonna know, so or I wouldn't
I
have
mean,
asked.
like, I got a lot of cases in my
I
brain.
know
I
you
can't
do.
remember every fact from every case until we get rewarmed up on it. Then, because this thing's coming. This trial is supposed to start February 26th. So we'll be fresh off of Aaron Spencer, which, if you did not watch last night's live, you really should. We think it's a pretty good one. And it would have prepared you for the cold opening. So, because last night's was pretty bumpy. I mean, we made it through it, but today's was a little better. We'll get it. We'll get it down. We'll get it down. I
I
can't wait
missed the
till I
whole
start
thing, so I'm
making
sure
Allie
it
do it.
was glorious.
It was definitely not glory. Wait, you were sitting there
No, I was
today or last night?
rebooting. No, today.
Oh, okay. Wait, no,
Yeah, I was rebooting.
no,
When
that
I
thing you were sitting when I hit live.
I was?
Yes. What? Wow. Perimenopause brain full effect.
No, then I didn't all I heard is, like, one word, and then it played the intro.
All right, let's stay on task here. Okay,
Okay.
so Corey, in the state's estimation, had tried to do this before. Eric had told, I think the partner in his business and close friend, and his family certainly thinks that Corey did this. Okay, so they arrest Corey. As Allison mentioned, there's this walk the dog letter, which we're going to get to. There's just this case has it all. But before we get to Corey being arrested, because there was a months-long investigation, she writes a book, a children's book about grieving, about your dead father. And she goes on to a local TV show. Again, if you go back into our earlier coverage, we have that. We cover it, we show it, we discuss it, we put our hands on our chins,
I
we
mean,
scratch our head, all that shit.
nothing bad about that unless, of course, you are the
She
person that caused
There's a lot bad about it if you're the one who
that
killed your husband.
facilitated the death.
Yeah, otherwise, it's kind of a thoughtful thing to do, but if it's the other way, it's fucking
Sick,
nefarious, man.
right? Demented.
Demented. All right, so what we've got going on today, so they obviously arrest her, and we're gonna get into what they're going on, what's gonna be happening over the next couple of days, okay? So, multiple motions to suppress have been filed. As I said, trial is bearing down. They've got to get these things heard. You guys, if you guys haven't seen this judge, you're gonna like him. He's got good hair. He's got a deep, froggy voice that you guys are gonna like, and he's on top of his shit. So
I
I
don't
have
I don't remember him from
you'll
the
remember him when you
once
hear
I
him
see him.
speak, yeah,
Yeah.
and when you hear him talk, he's got a very, yeah, I've got a very deep, he's like froggy, he's deep. But you guys, I predict, because we're obviously going to be covering this trial streaming, you guys are gonna love this judge by the end of the trial. That's my prediction. All right, so we got multiple motions to suppress. We've got a phone seizure. So the defense is arguing that the cops illegally seized Corey's phone during
Okay,
an
now
April.
this one I might remember. They were outside of her house?
It says the motion says that she was it was during a traffic stop
Oh,
without
see,
a proper warrant. So,
okay, I'm
but
mixing that up with a totally different one.
no, but there were two different scenarios with the phone. Like you're right about the one. There was one that happened like outside of the house. This could be the same one if the traffic stop happened like on her driveway, like if they followed her in. Because it was we did cover this as well. And I wish that I had like the sterling memory to remember all the facts about it. But we just know that this particular phone was taken by police after a traffic stop without a warrant. Okay. The defense is also claiming that she's then questioned for 5 hours without being read her Miranda rights. so that's a problem.
I'm
There's a
assuming
ton
the
of
state's gonna argue she was not in custody at the time.
yeah, come on, dude. For 5 hours?
She came in on her own. She drove her own car. There was a window in the room. The door was closed but unlocked.
Unlocked. Yeah, yeah.
And we brought her something to drink and ate and made sure she was comfortable.
And we told her that she could leave if she wanted to. They always say that.
I mean, that one's a big one. If they do tell you you can leave whenever you want, that
Yeah, but
you're
no one
showing
ever
her
believes it.
right,
It's like you've got 10 things making you feel like you can't leave, and then you have words coming out of their mouth
right.
saying that you can.
And you're sitting there, "Is this fucking guy gaslighting me? Because I know that door is probably locked."
These motherfuckers are not letting me walk out
"Oh,
of
I can leave, can I? Okay."
there. See, if you get in front of that, if you're law enforcement, just read them their Miranda rights, then they know. Like there's no question. They're like, wait, am I under arrest? Okay, fuck you, I'm leaving. Bye. Take care now. Hey, take care. It's been real. All right. So there's also electronic data that they're trying to suppress. And that is a challenge to the warrants that gave the cops the access to her Apple accounts and her entire digital life.
So I'm assuming overly broad and not no parameters, no date, time parameters, no content parameters?
Sounds right.
I mean, that's a
And
big one in this day and age. The Supreme Court has come down hard on it, but you still see it happening. It's been years, and you still see it happening.
yeah, I mean, is our digital life our new castle?
Yeah.
I mean, it kinda is. Notebook seizure. So the defense claims that a notebook that was seized from her home contained privileged therapist patient information. They should
So
not have.
now, is that the therapist saying, "Keep a diary," or "Make notes to me"? Do we know? 'Cause now I'm afraid to ask you questions in case
Yeah,
you
I
don't
don't
know the
know.
answer.
Don't ask me any
Okay.
question. Like, what I'm saying is
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 what
what
you
you're
know.
limited to. That's it. And then we're
Alright,
gonna
y'all,
watch the
see if
hearing.
one of you remember. We're about to find it all out because it'll all be discussed at
Yes, it's
this
all gonna come out in
hearing,
the wash today
and
and
I
tomorrow.
do not blame my man, he cannot keep all these facts in
I
that
mean,
brain.
dude,
Too many
it's like
cases, too many
I'm like,
facts.
I can't even remember words anymore. I have so much shit going through my head. It's insane. It's
And
absolutely
that's a
insane.
wordsmith, y'all. Legit.
Yeah, I mean, I know a
Always
word
has
or
been.
2. I know a word or 2. And sometimes I'll sit there for like 6 seconds, like, what the fuck is that word? Oh man. Like, I don't
Man,
know.
you know how I feel. You've got
I
brain
don't I
fog.
don't like it. I don't like it. It's scaring me. I'm like, am I losing my shit? Do I need to take fish oil, like gallons of it per day to work on the brain?
I have to
I
say
need
I'm right along with, Cody in Tennessee because I actually just finished episode 33, part 3 of Buried Inside the John Wayne Gacy Investigation, and I think it was 2, actually, where I was just sitting there again, like, in awe of my man's words, just like, it's just every word is important and compelling. It's just crazy. It's crazy. So, hopefully when you're writing, you that 6 seconds to remember a word's not gonna be a
yeah, that doesn't
a
that
thing.
doesn't happen when I'm writing, so
Right.
that's good. It's just like the recall sometimes. But I think it really does. Like, I really do have a lot of shit on my mind.
Yeah.
A lot of shit on my mind, and it's not just the cases themselves, it's like running the channel,
Yeah.
like constant in a constant state of panic that I haven't gotten a new Garcia out. It's like that thing is weighing over me. I just need to do it. I might dip out on you for like a week, let you run the channel, and then I just finished Garcia. I gotta do it.
I'll I'll do it. I mean, especially if it's a trial, I don't mind.
Yeah, for sure.
I'm just not gonna just get up here and talk. "Hi. How you
Hey,
guys doing?"
hey, hey.
I dipped on you last night to deal with my shoulder, and you still went like another 45 minutes, and there was
No,
only, like,
no,
15 comments left.
no.
It seemed like it.
I went like 10 minutes.
No.
Yes.
Alright, I'll have to watch it.
It was only like a 2-hour live,
Alright.
and we were wrapping the motions up at like 1 hour 50.
Right.
Um, okay, so those are a few of the things that they're looking to suppress in terms of evidence statements, you know, all the things. Okay. Then we move on to the walk the dog letter. Now, if you don't know anything about the walk the dog letter, this is an infamous, infamous letter that was found in Kouri's cell. Oh, all right. Hold on. We're up. We're up.
Well,
Hold
we
on.
can. Well,
Hold on.
and you will hear about it more.
Oh, wait. I got to do this through Google, right? So that when I'm sharing. Sorry. Hold on.
Wait, the
Oh.
internet? It doesn't matter what internet.
No, that's not what I'm saying. I got to do it like on the Chrome tab. Okay.
Why? What were you doing it on?
Like window, you know, the other thing you can do it on. Okay.
It's not on the list for.
Okay.
Yes, Your Honor.
The
Lewis.
Yes, Your Honor.
Oh yeah, I remember
see, I
him.
can't even.
Today.
Right.
Oh my lord, it's been going.
No, it hasn't.
Counsel, as I understand it, we're here today to address the defendant's motions to exclude 3 of the state's experts. Is that correct, Ms. Lewis?
Yes, Your Honor.
Okay, how's the sound? First and foremost, like it sounds pretty good to me. How's it sound for you, Bay?
Good to me.
Clear? Okay, good.
States recently filed a motion to exclude one of the defendant's experts not on the list for today. We'll address that in some fashion in the future. Yes.
Yes.
Okay.
If it's low for y'all, crank it on your end. There's nothing I can do. We're not doing the thing where Allie puts the the additional booster on that turned her into mono Allie instead of stereo Allie. So just turn up your volume a little bit, because I'm getting plenty of people that says sounds good.
Ms. Lewis, do you have a plan on how you want to proceed?
Your Honor.
Oh, it's a preliminary matter. My apologies.
Thank you, Your Honor.
Of course.
I thought he said Miss Lucy. Mr. Lucy.
Your Honor, the state wants to ask the court to make additional findings in connection with its order from yesterday denying the state's motion to determine admissibility of evidence. The court's findings regarding the defendant's financial crimes as it relates to the state's pecuniary gain element argument is clear. In its briefing, the state raised 2 additional arguments that the state asks the court to address. The first is that the defendant caused Eric Richins' death to cover up her financial crimes, and this proves an additional motive as well as the identity and intent elements. And the second argument is that the defendant's...
I'm sorry, no, I just am having trouble hearing. I need you to pull down the mic.
Thank you. Well done.
And the second argument, Your Honor, is that the defendant's financial crimes show that causing Eric Richins' death was her last resort, and this proves the identity and intent elements. The state asks that the court make intrinsic evidence findings on these 2 arguments and additional findings under Rule 404, as these additional arguments increase the probative, in the state's view, increase the probative value of the financial crimes evidence. Finally, Your Honor, regarding footnote 3 of the court's ruling, the state asks that the court note that the state advanced its complete the story argument in its moving papers before Blackwing issued, and then in its reply papers revised its argument to comport with Blackwing.
Pause, babe.
Yeah, let me be clear. I understood your arguments. I just didn't find them persuasive.
Oh, you love him. Like, you made me
Oh man, we got to rewind that.
Mm.
I just want to let the people know, and I don't know this for sure, but I'm assuming what he's talking about is the complete the story argument is like that the cops get on the stand and sometimes put in hearsay and give a bunch of information that's completely irrelevant because it tells the whole story. And apparently there must have been a new case that came down that changed that, and they're not allowed to do that anymore. Or it's some version of that, and maybe the judge will comment further. But yeah, we got to back that up because it's the wrong place to say pause. Yeah, that was awesome.
All right, okay, so let's go.
The state
Revised its argument to comport with Blackwing. Thank you, sir.
Yeah, let me be clear.
Yeah.
I understood your arguments. I just didn't find them persuasive. The state simply hasn't carried its burden to show a sufficient or persuasive basis that the arguments you just described satisfy the legal standard for intrinsic
Sure.
or provide a sufficient or persuasive basis to avoid the court's view of the balancing of the propensity inference that is most likely to be drawn under 404B, which implicates the 403 analysis the court made.
Your Honor, I appreciate that. And I don't think that comes through in the ruling. I think the ruling very clearly and specifically addresses the pecuniary gain. And the court, may have built in its thinking as to the other two of the state's arguments, but I don't know that that is reflected in the ruling. And I think it would help if it was.
Okay. I understand your position.
I'll make it
Thank
clear
you.
now.
Anything else on a preliminary basis?
No, Your Honor.
Okay.
All right, pause it
Very
real
good.
quick because I was way wrong, and DB's
Ms.
comment
Lewis, my
helps as
apologies.
well. So it sounds instead they were talking about other crimes or things that could be defined as other crimes. DB's saying that that was the financial crimes, and that's to complete the story, I guess, as far as their motive, maybe. Either way, a new case came down that changed that, and which is why the state said that since that case came down, they revised their arguments to be in compliance with that. Either way, the judge wasn't hearing it, but the state, and maybe the judge is about to address it, the state was just asking for a little clarity there because it seemed what he took from this breath, what the judge just said was like, financial crimes are out. And the state seemed to think that the prior ruling wasn't so specifically limiting.
I mean, look, we all know that motive does not have to be proved by the state. In this case, though, I mean, man, the motive is everything. Like the money shit. Because she was in this, this business where she was flipping houses, and she had sunk a fuck ton of money into this big ass, glorious looking like Utah mansion, and she was leveraged to the hilt. Like she was in financial dire straits. And if they're not able to get that motive in, it's going to be a much tougher sell for them. Like, because otherwise by, just looking at the face of the family, they seem to be pretty good. They had the kids.
I mean,
He
how
was
good
making a
can you
bunch of money.
be if you get sick and your first guess is my wife did something to my sandwich?
I
How
mean,
good
right,
could you be?
right.
And the
But
walk
he-
the dog letter, it's I don't
But that
remember.
links back to the financial shit. Like he was privy to her like rooting around in the money,
Well, that was
doing shit.
one thing I was going to say, and I have to revisit the letter. I don't remember all of it offhand, just that it was not a good look. That just because you write it out to say like, remind my brother X, Y, and Z doesn't mean you're making up X, Y, and Z. It could mean that you want to make sure he conveys it. It could mean like he doesn't know this, but it's true. It doesn't necessarily mean it's completely and totally fiction.
Yeah, no, well, and Brittany's right. I mean, they're certainly going to be able to show her debt. I mean, like, I'm assuming that they're going to allow that to come in terms of what her debt was. I mean, that's a devastating blow. Like in terms of, like, I want to see what that ruling was because that, like, I want to see what he's limiting them to.
And maybe he's about to bring him back and explain
Because
it
that's
better.
that could be like a death knell. Like if you don't have that aspect of it to where she needed the money, otherwise her entire kingdom, her little real estate kingdom was about to cave in on her. I don't know. But before we do that, one of our ride or dies, Christy Carroll, it's her birthday today. Happy birthday to you.
ya.
Happy
Happy
I wasn't
birthday.
even waiting for you because you always hate doing it with me. So I was just
I was trying to get, I was trying to
All right,
wait.
you want to try it with me? Let's do it.
You start and I'll come in.
Okay. 1, 2, 3, go.
Happy birthday.
To you. Wait, see, we were on, we sounded like, for you, I think you're on delay. So it sounds like we're off when we were really on. Happy birthday to you. Happy birthday to you. Happy birthday. Happy birthday. Oh God, you're killing me. Just happy birthday, Christy. We love you so much.
And so, to Brittany's point, Bob, you believe that they're going to be able to show the debt to some extent, but it sounds like he's kicking financial crimes. We're going to look for more clarity on the issue.
Yeah. We'll
and maybe he's about to, he called him back. So let's see.
All right. We'll see what's up.
No, it's okay. You can sit down. Oh, go ahead.
Your Honor, I did want to ask, can I move in and out of the courtroom as business requires?
Out of the well or out of the courtroom?
Both.
Yes, that's fine.
Thank you, sir.
Thank you. Ms. Lewis, we're here to talk about 3 experts. Happy to handle those in any particular order. Happy to have some legal argument and colloquy before after taking testimony if necessary. What's your view of what the defense needs to do today?
Well, we're handling different experts, but if we could maybe handle Ms. Amon and Dr. Fox first. I think that if Ms. Amon were to testify and then Dr. Fox, and then we could handle that. And then Kathy, you're doing
the other 2.
And then Ms. Nestor's doing the other 2. So I don't know if you prefer an order on those. So either order on the others.
And forgive me, with respect to Dr. Fox, nobody's challenged her.
No, she's going to testify if the court needs to hear it about the scientific reliability of the pathway to violence and why it should be excluded as under 702.
So let's talk about that structurally. Okay. If I have one former FBI agent saying this is not the way we do it in the behavioral science realm, and I have another former FBI agent saying this is how we routinely do it in the behavioral science realm, doesn't that go to weight rather than admissibility?
Well, possibly, but I think it might be more extreme than that. And that's why I think it's important we hear their testimony. From my understanding, that the pathway to violence has not been used particularly in courtrooms and doesn't come anywhere close to meeting the reliability standard under 702. And Dr. Fox, formerly when she worked for the FBI, also worked in this area and has a lot of information about how that study was conducted. And it could be a balancing act, but I actually think it might be such a huge difference that it would go to admissibility and not wait.
Okay. I have some questions for the state on
love this judge
Amon first.
Cutting through the bullshit.
May I just briefly address the court?
Sure.
Then Ms. Sherbanek will address Amon.
Okay.
Your Honor, because it's the state's belief that the defense has not even met its minimal requirements under Rule 12.
Pleading requirements.
That they specify sufficient legal and factual grounds for the motion. Now, even assuming the court disagrees with that, the papers sufficiently address the threshold showing. As the court is well aware, after Ramash, after cases like Clopton and Gunn-Hildary and the new Rule 702 flipped Ramash, which tended to keep a very narrow gate to allow very few witnesses through, it sort of flipped it upside down, so it catches almost anything. And even if there's 2 witnesses who say the opposite thing, they can still come in under that new 702. And by virtue of the papers, the state believes it has met its burden of a threshold showing. Now, the court wishes to address specific issues. I just wanted to lay that groundwork. If the court has specific questions, we've got all our witnesses ready to go, as the court can tell. Mr. Throckmorton is here, and then the other two are on the line. So if the court wishes to proceed on to specific questions about Ms. Ammon, then Ms. Shervanack can address that.
I appreciate the argument. The defendant's initial briefing was certainly sufficient enough for the state to file an opposition brief that had legal analysis, citation to cases, and consideration of the specifics of each witness's testimony. So the state's argument regarding the insufficiency of the defendant's initial briefing is respectfully rejected. I have specific questions regarding each witness within the framework that you described, 702, and then if we're past 702, we have to deal with Rule 403, maybe. So whose witness is Ms. Ammon?
Ms.
Ms. Sherman, I
Shervanack.
can ask you some questions.
Of course.
You just got to pull that mic closer to you. Okay. In its brief, in opposition to the defendant's motion to exclude Ms. Ammon's testimony, on 2 occasions and in bold print, the state says Ms. Ammon may become helpful to the jury. Under what set of twists and turns at trial do you see Ms. Ammon testifying? Is it in the state's case in chief, or only potentially in the state's rebuttal case, depending on the arguments and other testimony that comes in from the defense case?
The latter, Your Honor. It would be part of our rebuttal case, depending on what potential theories, evidence, witnesses come in through defendant's presentation.
And one of the examples the state gave was, forgive me, that in the state's view, Ms. Ammon's testimony may be helpful to the trier of fact to rebut an argument that, hey, this doesn't happen like this. This is not the way violence gets committed. Wives and mothers don't suddenly kill their husbands. And I understood the state to be saying, well, there's a progression here. People form this plan, unless it's the emotional pathway to violence. But this planned pathway to violence has a progression. It's been studied. This is how it works. Am I inferring the state's argument correctly?
In part,
Okay.
I think we don't know which theories, of course, defendant will put forth, but there are multiple theories that could come out at trial where Ms. Ammon's testimony becomes relevant to assist the jury in placing the facts and evidence that they have heard into an analytical framework. And again, Ms. Ammon's testimony, and I don't think this is clear from the defense's objection or from their reply, she is a blind expert. She
Right.
will not be saying Ms. Richins, and also from the declaration from Dr. Fox, they seem to all miss the point that Molly Ammon will not be saying Ms. Richins fits this profile, therefore she committed murder.
Right.
That's not the testimony. That's not what we would elicit. We agree that would be improper, and that's not our intention with Ms. Ammon's testimony. It's more to assist the jury in a framework to understand how targeted violence occurs. Again,
Sometimes, right?
well, yes, but also Ms. Ammon could describe that in every targeted act of violence,
Every.
and this is part of her proffer, that there is a framework, a pathway to violence that perpetrators of targeted violence follow. Now, do they complete a couple steps and pause? Do they all follow the same timeline in the exact same sequence? Maybe not necessarily, but there is a framework of perpetrators of targeted violence who follow a pathway to the attack. And all of the targeted acts of violence that have been studied, the perpetrators follow this framework to some extent.
Okay. When you say all, you provoke
See, that's what I'm saying. Every. All?
some questions regarding the Diaz versus United States case that was cited in
Sure.
defendant's brief. Now, in fairness, that case has a holding that goes the other way, right? That said the expert there said, most cases it works like this. Most people that are transporting drugs know they're doing it. And a majority of the United States Supreme Court said, that's fine under Rule 704B. That's not
Shouldn't have been fine.
implication
Supreme
regarding the
Court
defendant's
sometimes.
mental state or what was in their mind, because it's most, not all. And is Ms. Amon in that bucket of blind experts, or is she going to say, no, this is how it works every time?
I think we would have to ask her that direct question,
And we'll
I
make
mean,
sure to change it now.
and she can explain to the court what her answer to that is and why. But I think to say all the time, always, is extreme. I
You
don't
just
think
said it.
that's what Ms. Amon's testimony would
but
be.
you
I would
just
rather
said it.
not speak for her. If that is in fact what her testimony would be, then we need to address that and explore it. But again, when we're talking about a retrospective analysis, which is part of what she's talking about in the studies of the pathway to violence, they know that these perpetrators have committed the ultimate act, right? They have perpetrated their attack. So that is a different analysis than to say, are there other folks who have started on the pathway to violence and not made it to the ultimate act, to the attack phase, if you will? Yes, those people exist. And Ms. Amon would not know who those people are.
I read her proper. She seems to explicitly acknowledge that people stop at various points
Right.
along the pathway.
That's my point. So
Okay.
to say that if you start on this pathway to violence, you ultimately will commit an attack regardless, all the time, always. No, that's not her testimony.
Okay.
And that's not factual. But for her to say in all of these multitudes, decades of studies of people who have committed a targeted act of violence, we know the end result. The attack has occurred. We can place those folks on a pathway to violence. We can put them on these steps and identify the steps that they took to that attack.
Okay.
Sounds like always again.
All right. Hold on a second, Ms. Lewis. Anything else you wanted to say at this point, Ms. Sugar?
Not unless the court has additional questions on that point.
No, I understand the state's position. Ms. Lewis.
Well, Your Honor, listening to this, it might actually make more sense for Dr. Fox to go first. I understand the threshold is low. However, under Rule 702, the argument here is this is not generally accepted in the relevant expert community.
Doesn't need to be, though. That's one of two ways to survive 702B. If it's based upon a scientific method or sufficient education, training, and experience that's reliably applied to
Yes.
sufficient facts and data. But as a blind expert, she doesn't need to apply it at all.
I disagree. There's a case, first of all, yeah, the argument is that under 702. There's a case that is out of the Ninth Circuit that is directly on point, and
Is it cited in your brief?
no, because I didn't know about it.
Okay,
It's
can
something
you
I
give it to me?
just discovered.
That's okay.
Anyway, it is United States versus Wells. Let me give you the site. 879 F 3rd 900. And that case was also a blind expert who is actually one of Ms. Amon's colleagues in writing the profile for violence. And his name is Dr. I don't know if it's Dr. Reed Malloy is the name of the expert, J.R. Malloy. And there's also, and yeah, I'm sorry, I actually just found this case yesterday. But there's also a 403 and 404B argument, because the way this works in courts when they admit profile testimony, which the Ninth Circuit reversed and said this testimony comes in only very, very limited circumstances. They talk about how it's typically used in drug courier cases. This was a case, a homicide case, where Dr. Malloy was using the precursor to the profile for violence. It has very much the same criteria. It has been modified since then. This was in 2017. And he did a profile of killings in the workplace. he was a blind expert, although he admitted on the stand that he had reviewed the case at hand, although he didn't testify. He testified as a blind expert, although he admitted he had reviewed the case and the defendant. And the court ruled that this is improper character evidence, among other problems, because what happens is the profiler testifies that, so people who commit, in this case, workplace murder, have characteristics X, Y, and Z. And then other witnesses get on and say, well, the defendant had characteristic X, Y, and Z. So therefore, in conformity with that character, he committed the murder.
Yeah, but this is different than that. Like, I've looked at Ms. Ammon's proffer. She doesn't make it that specific. I'm sensitive to that concern. And certainly if she was saying, when we look at domestic violence, homicides, what we see are the following characteristics almost universally. She doesn't do anything like that. There's no level of that kind of specificity. She talks more high level in terms of initial grievance, inability to let it go, form of a plan. I may be missummarizing here, but there's a higher level to it. And when we look at Diaz is even more specific, and somehow a majority of the United States Supreme Court is like, yeah, they said most, not all. So the trier of fact can draw distinctions. How do I apply Diaz to Ms. Ammon's testimony to say she can't come in?
I haven't looked at Diaz in a while. I'm sorry.
That is one you cited.
I know
right?
it is, and I did not reread that case. So I would actually
We can we'll take a break at some point.
need
We
a
can
moment to
compare.
review that, to be frank.
Okay, Ms. Shervanek.
Oh, I'm sorry.
Oh, okay.
I do think that it would be helpful to hear Dr. Fox's
Sure.
testimony. For one thing, this routinely isn't used. It's used at NBAU as an investigative technique sometimes,
Right.
but it's not used in the courtroom. And that's because of all these problems that Dr. Fox is much more qualified to address than I am in terms of it's junk science is what it is. It's not scientific. It's not used in the community. And I think that does stop it even under our low threshold here.
Well, hold on, but come back to the specific context of this case. The state has noticed Ms. Ammon as a potential rebuttal expert, if necessary, to respond to an argument from a defense witness to the effect of, this is not the way it works. This allegation that Kouri Richins killed her husband is not credible because wives don't kill their husbands. People don't just snap and do this. That would seem to make this kind of explanation of how violent crimes are planned and executed helpful to the trier of fact under 702A to say, well, actually, based upon a retrospective study by the FBI Behavioral Science Unit, there is a pathway in which people do this. Full stop. And then the trier of fact can say this is within or without that body of cases. Tell me why that isn't allowable under Utah's Rule 702.
Well,
Now, first of all, if the defense doesn't make such an argument, then the state never calls Ms. Ammon.
I think we're going to need some clarification beforehand. If Ms. Richins testifies and testifies that she did not do this,
That denies committing the crime.
the crime, then how does that not open the door for them to say, well, of course she committed the crime because she's on this pathway to violence?
No, I don't think they get to do that. That would be more like profiling.
Okay. I still have the whole 702 problem no matter how. And this is the first I've heard it's only going to be used in rebuttal. I think we would actually use less time if we let Dr. Fox
Happy to.
go through and explain the problems with the reliability of the science and then go from there, if that's all right.
Sure. Ms. Shervanek.
The only points I wanted to make, and the court has honed in on this, but in Dr. Fox's declaration that was submitted as an attachment, she analyzes the federal rule 702 and why Ms. Ammon's proffer does not fit within that. there are fundamental differences between the federal rule and the Utah rule, and I don't believe that it's helpful for the defense's witness to make a legal analysis about whether Ms. Amon's testimony does or does not comport with Rule 702. That is for the court to do. So
I agree, but I can sort that out.
And Dr. Fox is familiar with the Utah Rule 702 and is prepared to address that.
Well, yeah, but I don't need her to address the law at all. I just need her to tell me her
Right.
view.
I understand,
of
but
the
she hasn't
science.
now analyzed it under the Utah
Okay.
law. All right. Would it be all right if we go forward with Dr. Fox?
Sure.
All right.
Dr. Fox, good morning.
Hi, good morning.
Okay. Sounds like you can hear us okay.
I can.
Let me turn on the video in the courtroom so that you can see Ms. Lewis.
Good morning, Dr. Fox.
Hi, Ms. Lewis.
So could you just please state your name for the record and tell us what your current position is?
My name is Dr. Brianna Fox. I'm a tenured full professor in the Department of Criminology at the University of South Florida. I also hold courtesy appointments at the Department of Psychology and Mental Health Law and Policy, both at USF. I'm a faculty affiliate in the Mental Health Institute at USF, and I'm also the co-founder of the USF Center for Justice Research and Policy.
Thank you. And could you, did you want to swear her in? We didn't do that.
Yes, thank you.
Thank
Dr. Fox, would you please raise your right hand for me? Do you swear that the testimony you'll give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
All right, please proceed.
All right. And could you briefly describe your educational background for the court?
Yeah, well, I went to Penn State University. I dual majored in psychology and criminology. I was going to be a pre-law, but I actually changed tax. I went to the University of Florida to earn my master's. And then I earned my PhD instead of my JD from the University of Cambridge in England. My doctoral dissertation specifically evaluated the accuracy and reliability of offender profiling methods, which is obviously related to the issues before this court.
Thank you. And what's your experience with the FBI?
Well, I was an honors intern. That's how I started. I went on to get a position. They asked me to join them in the behavioral science unit as a research fellow. They were actually acutely aware of the problems that they were facing with Reddit assessment and how inaccurate it is. So that's actually why they brought me on, was to really bring that into the modern era, improve it, use statistics and science, which they were sorely lacking. So that's how I got my start. I worked in the behavioral science unit as a research fellow. I was doing research. I was going over to the BAU. I was training people like Ms. Amon, although I didn't actually work with her specifically, and trying to get them kind of brought up to modern standards. Then I got a position as an FBI special agent. I worked in the Las Vegas division. And in between there, I worked with the Tampa field office in the field of investigations group. I actually still work with the FBI. I just did a project with them out in Sacramento.
Let me ask you just briefly. You talked about that you worked with the BSU, and I know Ms. Amon has talked about the BAU. What's the difference between those two divisions?
Yeah, the BSU was really their research arm. That was where they were really tasked with doing the data analysis, trying to develop the new, latest, and best approaches for investigative techniques. We would then go on to train both people at the National Academy. That's a prestigious group of law enforcement that come in from around the globe. We would train them, so our methods would get disseminated into their investigations around the planet. But then we would also go to BAU. We would take what we were doing, implement it. We were also trying to train them to bring them kind of up to what we were doing over in the research arm. BAU was very operational. We were the research folks.
Okay. And have you published research relevant to offender profiling and violence risk?
Yeah, that's actually the main part of my job. I have more than 50 peer-reviewed articles. I've written 5 books. I have over 3,000 citations. My work has been published in the top journals in psychology, clinical psychology, law, sociology, criminology, developmental psychology. So my goal is to actually try to create more established and evidence-based risk factors, trying to understand the development of offending. Again, this is an area that we are really lacking in, so there's plenty of opportunity for that science and data-driven research.
Okay. And do you have experience in violence risk assessment or threat assessment?
Yes, I do. I have extensive experience in both violence risk assessment and threat assessment through my academic research. Obviously, I also get federal grants. I work a lot with the U.S. National Institute of Justice. I have applied professional experience working with law enforcement agencies. This was mentioned before this, but there is a distinction between investigative efforts and then obviously applied efforts in a legal setting. I would say that my experience as a FBI special agent and of course as a research fellow in the FBI's behavioral science unit, where I evaluated and then tried to help improve the scientific validity of both profiling and threat indicators, is what really has motivated me as a researcher, kind of trying to take that old school approach and modernize it, and really trying to assess the reliability and validity of violence risk assessments, as well as these theories of behavior. That's where I won the early career award in specifically my work on developing theory on why people become offenders.
All right. And you heard us talk in court about the different standards and rules. And have you familiarized yourself with the Utah standard in addition to the federal standard?
Yes, I have read about the Utah Rule of Evidence 702. I have testified as an expert in other cases, so I'm familiar with the federal rules of evidence. And I do understand as well just how to evaluate scientific merit and reliability. I was the editor of our field's premier journal, Justice Quarterly. So as a journal editor, it was my literal task to assess scientific merit and how we can really understand, is this a credible theory? Not every theory gets published just because it is a theory. It really has to meet certain standards.
Is there any objection to certifying that she is an expert in this particular area?
Nobody said she isn't.
Okay, just wanted to make sure as we move forward. All right, so are you familiar with the pathway to violence model?
Yes, I am.
And can you describe what that model proposes, just generally?
Yeah, so the Pathway to Violence model is a group-based descriptive framework. It outlines a sequence or phases of behaviors that are thought of being observed retrospectively among individuals. It's really applied almost exclusively to individuals that commit targeted acts of violence like mass shootings or terrorist attacks. To be clear, it is not a diagnostic tool. It is not a validated risk assessment tool, and it cannot be applied to individual cases. It was not created using data. It has no scientific testing or reliability. It is pure theory, and it was postulated by individuals that, frankly, I don't want this to sound mean, but they have no scientific training.
All right. And is it designed to diagnose or predict whether a specific individual will commit violence?
Again, no. It's a subjective, group-based descriptive framework. At best, it applies only to some cases. I thought the judge's explanation of it was great. It applies sometimes, but in other cases, it doesn't apply. So we really have no idea how often that occurs. It applies sometimes, except for when it doesn't. So it's completely disconnected from data and science.
What's the difference between a descriptive model and a predictive risk assessment?
Well, group-based descriptive models just summarize patterns or characteristics that are observed across groups of people on the average after the events have occurred. That's ones that are created using data. The ones that I'm familiar with, like when I worked in the FBI's behavioral science unit, the infamous, organized, disorganized profiles, they were created just like by thinking about what we see sometimes in cases, and sometimes we don't. Those have also been excluded as being admissible for that same reason. That doesn't mean that you can't use them if you want to investigatively, but you can't use that later on in court to say, this person fits this profile. So predictive risk assessments, by contrast, are empirically tested. You want to be able to forecast individual outcomes before they occur. And just, a distinction from the group-based descriptive method, you really have no idea how often it applies or doesn't. Unless there's associated data, you really have no clue how often is it accurate. You can use the words mostly, but it's one person's opinion. There hasn't been a scientific evaluation of this to actually say this often it applies, this often it doesn't. There's no known error rate. There's no accuracy rate. There's no reliability measure. It's just a, I guess, guess.
So that's why it's important in a legal framework that the pathway to violence is descriptive framework and not predictive.
Yeah, it's descriptive. It would be like saying that both of us are female, and females are more prone to, I'm trying to even think of an example that wouldn't, that would be kind of as like detached from the data. But we could say, well, both these women would, engage in, they're both in a courtroom today, so women tend to be in courtrooms. It's like, well, just because the two, people that our judges seen today both are in a courtroom, that doesn't mean all women are in a courtroom. The example I use in my undergraduate course: every person who went to the moon eats chicken. That doesn't mean that everyone eats chicken goes to the moon.
All right. So does the pathway to violence, does it tell us how likely?
All right. Well, I don't know about y'all. She's convinced me. Junk science can't come in. It's not admissible. She's a pretty good witness. Pretty good witness.
It is that someone will engage in violence?
No, that's a major flaw of it. It has no estimates for the likelihood, probability, risk. It doesn't quantify anything. There's no statistical basis behind it. There's no prospective testing, no base rate adjustment, no error rate. All the reliability measures that we would see as scientists, it has none of those.
And can it distinguish between people who commit violence and those who don't commit violence?
No, I think I keep on saying this. Another major problem I have with this is there are lots of people that have those grievances. I can name like so many cases off the top of my head that will never go on to commit violence. And we have no idea how often people will follow this pathway and literally never commit violence, or they do some things and then stop and don't commit violence. There's no associated numbers with these. So people who engage in, out of a larger group and engage in similar grievances, thoughts, and behaviors and never engage in violence, we are unaware of. What the pathway to violence model is doing, they're selecting on the dependent variable. They're selecting people that commit violence and say, oh, all those people do this based on, our thoughts. It's not even based on their analysis of data.
All right. So addressing the reliability and the 702 standards, has the pathway to violence been published in peer-reviewed journals?
You missed quite a bit. What were you doing?
I had a client call, but then I was following along at the end there. I do want to say, I think that the judge is going to distinguish this from scientific evidence and get it in under a witness being qualified by knowledge, skill, experience, or training to provide information where they don't require that the expert has reliably applied the principles and methods to the facts of the case. They just say that the expert opinion reflects a reliable application of the principles. So
that's the point. That's the part you missed. There is no principles here. There's no data that's used. Like, you missed the whole.
No, I did.
Like,
I heard that that's not relied on data, and it's like just somebody's thoughts and their theories and their, but I think the judge might say all of that goes to weight.
what value does it have?
Well, I need to look at this case, this Diaz case that he's talking about, to see, because from what I heard, she said that this was designed to talk about like mass murderers and targeted attacks, not domestic violence.
Well, I think it was more based on the leveling up to becoming a murderer, that was my understanding.
And that might be true because I missed
But
chunk
I
of it.
think that was kind of what the preface conversation with the judge was about.
Well, you can tell from his, so I missed that part, but from what he had said initially going into it, it seemed that he was talking about 702A and not continue considering this scientific evidence, but just a person with, special knowledge And
Yeah, but
that
what value does that bring in a criminal trial? Like it's like that concept that it's a hit or miss proposition to me means it doesn't come in.
and he almost said the
Especially
more
when there's no empirical data to support anything that this person's going to get on the stand and say. Because it's like they're trying to get over the hump of like, well, how does this, like Guy Vermectin said it as a joke, but she's too pretty to be guilty. Like how does this wife like all of a sudden turn into a murderer? And they're going to put somebody on the stand that has no data to support anything they're saying, just to say, oh, well, she fits this profile that a bunch of people in the room said, can happen. Like that's essentially what this person would be testifying to. Person they're
no, I
trying to
hear
keep
you.
excluded. I don't know. But I mean, if we're to glean anything from the judge's comments earlier, I tend to agree with you. I tend to think that he's going to find a way to get it in.
But
Did you
maybe
pull up
some of this will change it.
702? Did
Yeah,
you
but they
pull up
have the
Utah's?
old rule 702 listed for Utah. So I went to like just looking at the federal rules of evidence 702 because it changed in 2023, and clearly that's what they're talking about, this change to 702 that makes it easier to get information
We'll
in.
keep it stored and let's go like when we get a break, let's go
Okay.
back and peep it because we'll have more argument at that point.
All right.
No, I was actually shocked. I thought I heard somebody say that before this. I trust when I say I've researched this extensively. Book chapters and governmental white papers are not publications. Those are, they don't undergo a peer review process. I've written 5 books, so I am aware of the process. It's not that. I've also written governmental white papers. There's no peer review process. You could write whatever you want as long as the publisher agrees to print it, you're good to go. And Ms. Amon's proffer, the pathway to violence model, was just discussed only one time in a published paper in the Journal of Forensic Sciences. Again, I don't know how to say this without sounding like I'm mean, but that's a predatory journal. They like write to me often and like ask me if they can publish whatever I want in that journal. It's not like a legitimate, like valid journal. That paper that was published in the Journal of Forensic Sciences, it wasn't even about the pathway to violence model. It was about political assassination in the United States. The pathway to violence model was mentioned. It wasn't even a study of the pathway to violence model. So it's never been published in a peer-reviewed journal ever to date. And I think that's saying a lot.
When discussing reliability, why is it important? I asked this, I've had battles on this before with experts, but why is it important that it be published in peer review journals as opposed to other journals or just being available?
Yeah, I mean, it's not so high of a standard, but that's a standard for a scientific merit and reliability. We don't give things that, stamp of approval if it's not reliable and valid. I mean, that's not the highest bar in the world. So to say it was never published in a peer-reviewed journal, I really think that's saying a lot.
Okay. Does the pathway to violence have a standardized methodology?
No, and that's actually one of the reasons why it hasn't been published, I would assume, as a journal editor. There's no operating manual. Everybody what I determine to be a grievance could be different than what Ms. Amon thinks is a grievance or what you think is a grievance. There's no coding sheets. There's no requirement for evaluators to determine these things using the same criteria. There's no uniform objectivity in this. Everybody can look at it and say, that fits, and there's subjective interpretation and value behind it, meaning evaluators are not constrained to apply the term the same way across different cases.
All right. So different evaluators could look at the exact same fact pattern and come up with opposite conclusions. Is that fair?
Yes, absolutely. Because there is no standardized criteria for what these things mean. They're barely even defined because again, there's so little peer-reviewed papers even discussing it, let alone zero on it. They don't even invoke it in peer-reviewed publications. It's sort of constrained to these like side areas. So an example of this would be 2 evaluators could use the pathway to violence model and can reach opposite conclusions. And there's no way to determine who's correct.
Okay. So is that consistent with things that are admitted as being scientifically reliable?
No, I think it's actually the opposite. Reliability at its core means, the example again I use in my undergraduate course is, if you have two people stand on two scales, you would expect that the scales say the same number. That's reliable. If we have somebody stand on two scales at my gym and at my doctor's office, and there's two different results, it's literally not reliable. That's the definition of reliability. Or if you stand on the same scale every day and all of a sudden you're getting different results, it could mean that your weight has changed, but if it's 2 times in the same day, probably not. It means your scale is broken. So, this model is broken.
Okay. Is that connected to inter-rater reliability? I know we had discussed that, and I wasn't entirely clear myself on how that is relevant to the acceptable.
Yeah, inter-rater reliability is, again, since reliability is such a key foundational element of what is scientifically valid, inter-rater reliability is basically this idea that if two people use the same construct, will they get the same result? And if people are having the same scale, implementing it, and get different answers, it's not reliable. And it just has a basic foundational level. So you would want the same instrument applied and to get similar results. So two people should be able to look at the same case and have a general agreement that this person either meets these criteria, they would agree they're both experiencing a grievance. That's something that you would expect. Inter-rater reliability, that's mandated for something to be considered reliable. I would actually argue that this doesn't even have the ability to determine if it's reliable, since there's been no study conducted ever on the inter-rater reliability on the pathway to violence model.
Does it have a known error rate?
No. And that's obviously a problem in terms of false positives. You could say, I think this person, or this is what tends to occur on the majority, that somebody would be on this pathway to violence. You have no idea how often that happens. You have no idea how often you're wrong. You could say that is the case, but we have no idea what percentile of the population actually fits that model, because there is no known error rate.
And why is that a problem for in terms of admissibility?
Yeah, well, without an error rate, the court cannot assess reliability. A method that you can't quantify how often it's wrong if you literally don't have that number. And this has never been studied. It has no data behind it, so you have no idea how often it's incorrect.
Okay, and has the model ever been applied prospectively to identify individuals then who later actually do go on and commit violence?
Never.
All right. Is there any scientific data showing how often? I'm almost done, but I'm sorry, what?
Oh, I didn't say anything. My apologies.
Oh, okay. Is there any scientific data showing how often people identified as being on the pathway then actually never do commit violence?
No, and
Real quick. Yeah, I agree that the scale analogy was fucking stupid. Like, it's not a good analogy at all. It's like you can urinate and be 1.5 pounds lighter. You can take a huge shit and be 3 pounds lighter. So in terms of your own scale, and my wife battles the scale enough. She's like, this fucking thing's broken.
They're all broken. They're all broken.
But the overarching theme for me is that there's no empirical data that is used, that this is just theory, strictly theory, and the BAU may use it, but I think that the reality that it's a bunch of people in a room and they look at things that are similar in cases and things that are dissimilar, and then they surmise a theory. I don't think you can. I'd feel very uncomfortable having this type of evidence coming in against our client in order to try to make it fit, to get people over the hump of look at her, there's no way this woman, like that kind of shit, by just espousing some kind of theory that was cooked up in a room by a bunch of feds who
Well, I hope they're not like, just look at her. She didn't kill her husband.
I mean, like that, that's kind of what they're like. What other reason are you putting this type of witness on?
I think they're saying that if the defense tries to demonstrate that there was like no reason, like that everything was good and she's never done anything like this before, and like trying to make it seem like that that it's unexplainable based on facts, not like, look at her. Look at her over there. She didn't kill her husband. Look at her. She's beautiful.
Yeah, I don't know. I guess the way that I try to think about it is, if we had repped Richard Allen, would we want the witness that the state's putting on if they had surmised that Allen doesn't fit the profile? He's got no history. We didn't find any kind of, fucked up shit in his browsers or his search
Right,
history.
hell no, hell
He's,
no.
I don't
And
know.
I was looking at the rule, and the federal rule of evidence changed to be stricter, to let less in. And maybe I misunderstood what they said earlier, or just forgot. I thought they were trying to say that the new rule lets more in, and maybe they did say it opposite, you know. And the judge's whole A and B thing, there's still an A and a B in. Yeah, they haven't changed the Utah, you know, rule even on Westlaw. Now I've went to look at it since 2011, but it says in A, subject to the requirements of B. So there are still all those requirements no matter which section they go under. And you said we'll read it later. I just don't understand what the judge was talking about, and he's been on point. So
Yeah,
I don't
he's
know.
pretty on point. He'll get to it. Yeah, Larisha. So this is a motion to bar this evidence that the state's looking to put on, regarding kind of the course of building up to committing a murder. So
The characteristics or
yeah,
things that occur. Right.
whatever, yeah, whatever they've cooked up in terms of that, it could explain how this mother, this wife,
No
woman,
criminal history.
no criminal history, the pathway to violence, right? Like that title alone sounds like bullshit to me.
As a rebuttal to a defense expert is what the state has said, that they will be keeping their expert as a rebuttal to the state's expert. Then this expert would have to be Sir rebuttal, but the reason
Oh,
the
I thought
state's
she was the witness on the stand now was the rebuttal to the state's witness. I
yeah,
thought.
but the state said they're going to put that witness on their rebuttal case.
Oh, right. So
It would be Sir rebuttal.
right, but that as you indicated, that would mean that the defense is putting on an expert to say that she does
This
fit the
person.
profile, right?
Right, to say that everything that woman just said there, or that expert said, is bullshit, and then the state would still get the last word. I mean, shit, you just had it in Garcia. I mean, Gacy. And Sir rebuttals are not typical, but I think the reason for calling her now is so that the judge that they're imploring the judge to use his gatekeeping, function to say this: no matter what happens in the defense's case, the state can never call a witness to testify about the pathway to violence.
Actually never do commit violence.
No,
Oh, okay. Is there any scientific data showing how often people identified as being on the pathway then actually never do commit violence?
no, and without overemphasizing this, there is no reliable data on this. And I'm emphasizing it because that was why I was brought into the behavioral science unit. I was the first and only person at the FBI to do research on mass shooters and terrorists on the pathway to violence. It was literally the task I had. I was the person who did it. And this was in 2000. The first time I started on it was 2010. And then the process of getting access to data was, as you can imagine, quite difficult. I was going through all of it. I was trying to code it. I was the first person to do it. No one had done it before. There was no study ever on this. And what I've been finding, I didn't have the resources to really complete this in the way it should have been done, and it was never published. So that's why I'm also quite sure there's no publications on it. But it really was so much more complicated than what the pathway to violence model suggests. That's such an oversimplification, and it's so inapplicable in so many circumstances. And like I said, there's no known error rate. So we know it's wrong, we just don't know how wrong it is.
So what data was it developed from, the model?
The pathway to violence model, or what I was doing?
The pathway to violence model.
Oh,
No data.
It's not based on any data. It's based on, like I teach a forensic psychology course, and so there's a great line. I really respect the original profilers. What they did was, groundbreaking back in the 1970s, right? But obviously a lot has happened since 1977. What we've expected, in court, DNA, our standards for what we admit into court has changed a lot. But back then, 1977, when they were developing this, that was what they thought was best. And they developed it off of what they called intuition, educated guesswork, and hunches. And so I always teach my students, like, that was the 70s way, but we're doing this differently now. And the pathway to violence model
guesswork.
is the same approach.
Educated what?
Educated guesses.
Wow.
Okay. So
It's based on
Ms.
vibes,
Amon,
right?
and I guess suppose others who've worked on the
This
model.
shouldn't be allowed in. It
I'm a
doesn't
big,
go to waste.
I'm a big vibe guy. Guy gives me a murdery vibe. I get the murdery vibe. Sounds like
I
my
mean, he
kind
can
of study.
vibe out a psychopath. That guy's a complete psychopath.
Excuse me, sociopath.
Sociopath.
Come on, dude.
Believe that it can be applied on. Okay. So Ms. Amon, and I guess suppose others who've worked on the model, believe that it can be applied after an offense has occurred. And is it scientifically valid after offense has occurred to then go back and use the pathway of violence model?
No, I mean, that's like a basic logical fallacy. That was probably on your LSAT exam, you can't do that. Applying a descriptive model retrospectively to infer that the person therefore fits it is like predicting the lottery numbers after the drawing already occurred. I don't know. I don't know how to describe this another way. It just doesn't make logical sense. It is a logical fallacy to do so.
Well, in fact, an example of that fallacy is the 9/11 attacks. Is that right?
Yes, that actually, there's the pathways to radicalization. We've, toyed around with this idea. They've all been kicked around and kicked down. But that one was the pathways to radicalization profile. And it was this like traits shared by attackers. They're young, male, Middle Eastern, and you could say, looking at, the 9/11 attacks, yeah, they all fit that profile. But when you apply it retrospectively, there's 55 million, right, plus people that fit that are young Middle Eastern males. Like literally it goes down from, everybody who, commits terrorist attacks fit this profile to 0.00000, like I don't even know how many digits out, 0%. It's basically 0%. It doesn't fit at all. There's no validity. There's so many people that fit that profile and never go on to commit a terrorist attack. So what's the actual value of saying this is a pathway to radicalization? There's so many people that would fit that and never go on to commit the act. Cherry picking after the fact and saying, all the people fit that. Not only is that a logical fallacy, I would actually say that's, it could be a violation of people's rights, to be able to make that implication of them just without even having 1% accuracy rate.
So how does that relate to the pathway to violence model?
The pathway to violence suffers the same fatal flaw. By implying these group level descriptives, you're first of all applying it, and we have no idea. It could apply to 1% of people that have a grievance. Go to a workplace nowadays, right? So many people have grievances. So many people are upset. They're feeling stressed by the economy, by their situation. They even may say, "I'm so stressed, I'm mad." They will never go on to commit violence. This is an extremely rare base rate event. And low base rate events have very high risk of false positives. And when you are now going to take that and enter it in as an expert opinion, obviously, just me as a scientist, as somebody who supports the research in this area, and of course, like as an American taxpayer, I feel very concerned by that.
So let me ask you, you heard the discussion before you testified about if Ms. Amon were to testify in rebuttal, that why someone who is a mother or someone who is in the position of Ms. Richins might commit this offense because of being on this pathway to violence. In your expert opinion, is that helpful to a jury, and why is that problematic?
Yeah, I actually think that the risks are so far beyond the benefits. I mean, there's so many people that experience grievances, anger, even violent ideations. There are a lot of studies on that. So there's plenty of research that can be discussed to talk about the base rate of those. They're high, but then when you look at the predictive ability, how often do they go on to predict violence? Extremely low. The reason is because, if we were that good at predicting violence, I mean, think about the problems we have when we're talking about parole. We're talking about, risk assessment when we're looking at releasing people. We're doing, my big NIJ grant was specifically to do risk assessment to try to identify people who are low, medium, and high risk. This is such a big area because we are so bad at it, even with huge amounts of data, huge amounts of research behind us. There's no way that something like this is able to be better than all of the research and data that we have based on hunches. Our data suggests that things like grievances, feeling anger, violent ideation, they have such a low predictive ability.
No, we're actually. I'm in a debate with my son.
Why?
And
Who's calling us out?
well, when we look down on our phones, people think we're fucking sleeping, which is, come on, we're not sleeping. You think we could sleep on balls? There's no way
I'm not on a
God's
ball.
green earth I could ever sleep on this thing. I'd roll right off of it, which would be amazing. No, so you guys know the scene from Pulp Fiction where Jules, Sam Jackson's character, the two hitmen, him and Travolta, are in there, and they go into the apartment, and Brad's eating Big Kahuna Burger.
Poor Brett.
It's not Brett. Did you watch the clip?
I
He's
did,
not-
and you
I
know
don't
what?
care what
It
the
could
script
be
is
the way
saying.
he's saying it. Look at the big. It could because he's saying it sing-songy. Look at the big brain on Brett, and
What?
then
Brett?
enunciating the T.
Brett?
Yeah.
Brad? No, it's Brad.
Well,
Did you
IMDb
watch the
says the
clip?
guys. I did, but IMDb says the character in the movie's name is Brett.
But what they actually said in the movie, script be damned, is Brad. So whatever Quentin Tarantino wrote originally got changed by Sam Jackson because he definitely calls him Brad.
Well, but you don't.
Oh,
know
there you go. See, we lie on IMDb. Yeah, no, it's. Then I've been misquoting that line, which I've used thousands of times in my life, as Brad. Except
Right.
I
It's
haven't.
Brett. Nope.
It's not Brett. It's not Brett. You can't.
We're
I got to
gonna
go back.
watch the movie when we get off.
That's right. That's
We got to
what
watch the whole scene. He asks the people's names when he walks in, so we have to see
Yeah,
what
like
the
somebody
guy
tells him
says.
about. Like somebody tells him about Brad. Like
Brett.
earlier. Wow. Fucking.
I'm with our son on this.
Oh yeah, because Wiki is so fucking.
No, he's done his research. I fully trust him. We're gonna have to research this further.
Okay.
Chat's gonna say it's Brett, and it's a misquote.
Actually data, research and data that we have based on hunches. Our data suggests that things like
Yes, let's get the update out there. Jackson is withdrawn from the Reiner case.
What?
Yep. We don't know why.
He's like, I can't win this case.
I don't think that's it. I think it's probably money. I think that there was probably, hey, can you represent our brother at this thing? And he said, I'll need, I'm going to need a big amount of money to handle this case. They're probably like initially like, yeah. And then, maybe as more information, who knows? But I think ultimately it's the money. I don't think that Jackson's shying away from an insanity defense case.
So Spitfire says Reiner's going with the public defender. So Shaboog says she thinks it's money too.
Yeah.
I mean, he's not getting any access to the, anything left to him if he is right now under suspicion for causing their death.
No, yeah, the sibs would have to be fronting the dough for sure. So, I mean, that's so yeah, breaking news. Jackson's, which I'm relieved, frankly.
Why?
I don't know. I just like
Like, expound on this, please.
I do like for a lot of reasons that I don't necessarily want to get into. I just like to me, in terms of that case and the importance of it highlighting mental illness and mental health. Like I don't want Jackson to be the focal point as opposed to the issue, which I think is, I mean, if he's diagnosed with schizophrenia, it's an important trial in terms of mental illness and mental health because of the notoriety of the Reiner family and who they were in this country, starting with Carl Reiner and then Rob. And I mean, if you look at their history in Hollywood, they're fucking, Hollywood royalty. There's no question about it. I mean, when you bounce from, like I said, from Carl and then Rob starting out and All in the Family, and then the movies that Rob directed are legendary. So to me, it's a great case to really kind of highlight for everybody to start to come to grips
So
with
you
the
want
fact
him to
that
be
mental
talking
health.
more about mental health and not about his lawyers and what
Right.
the lawyers are wearing and what the
That's what I
lawyers
just
are
said.
doing.
Right. Just
I
like
hear
Alan
you.
Jackson,
right.
I have to talk about Karen fucking Reed when I'm talking about the Nick Reiner case. I don't want to do that. You know what I mean? Like, frankly, that's the reason I haven't covered it in terms of on our channel. I'm just like, it's like everybody's expending a lot of time and energy on the Reed civil trial, which I get it. I get this concept that, this thought that they're trying to get justice for John, but at the end of the day, it's a civil trial and it's about money. And, guys like Richard Allen are sitting in fucking prison, and like that's where people's energy, if you're worried, like, because money's one thing, just because you're never going to get justice from a civil case, not with the preponderance of the evidence being the burden. It's just like if you think that somebody's going to cave in a fucking deposition and say, yeah, we did this, yeah, you're dreaming. It's not
Right.
happening.
And by way of further update, the arraignment has been moved to February 23rd.
Yeah. So today was did they even arraign him, or did Jackson
No,
just
at
withdrew?
least Tracy's update to me says arraignment has been continued to 2/23.
Okay. All right.
Grievances, feeling this is able to be a big area because we are so bad at it, even with huge amounts of data, huge amounts of research behind us. There's no way that something like this is able to be better than all of the research and data that we have based on hunches. Our data suggests that things like grievances, feeling anger, violent ideation, they have such a low predictive ability to actually accurately predict violent behavior, because violence is a low base rate phenomenon. Lots of people have these types of feelings. Very few ever go on to commit violence. Even if you fit all of them, you literally have a low probability of actually committing violence. I could actually, look that up in a couple of minutes and tell you what the base rate is. But because this...
Yeah, I hear you, Kraken.
Wait, babe, if you don't put up the yes, thank you.
Kraken said, Bob, I disagree why people are still with Reed. A lot of us have been wrongly handled in the system. So we wanted to see it put to the man. Well, the man's not going to be put to in this civil case. I assure you of that. And
well, did the judge allow the counterclaims?
We don't know yet. We don't know yet.
Because then, if so, it could be, sticking it to the man. Hey, we might cover it some.
Yeah, I mean, we'll probably take a peek at it, but the bigger thing is, and you're kind of preaching to the choir here. Kraken with Allison and I, I mean, nobody wants it to be put to the man more than us. I'm just here to tell you, I'm not getting that vibe from that trial. It's got like every vibe of being a pissing contest, and just everything that I'm seeing that's surrounding it with like this this weird fucking bizarro world. Like I fell onto some live last night. I don't even know how it popped up. There's like some kind of like fundraiser war going on between the free Karen Reed people that is just so strange to me. I don't.
Yeah, but we don't need to cover any of that to cover the civil case, because here's what it is. It is entertaining, and it is a continuation of a case that people invested a lot of time and energy in. They
True.
know all the facts. So when they hear something, they know about it already. So that
True.
makes it a lot more interesting to like our viewers and people, like, instead of just hopping in, covering a trial and moving on. It's like, all the details about this. You know all the background. You know all the suspicion. You know what you hope to see, what you expect to see, who you believe, who you don't believe. So the continuation of that is entertaining and fascinating
Yeah, but
to
we're
the people.
7 years away from trial, if that
Well,
ever
right.
happens. And like I don't know if people are under the misimpression that we're going to know what's going on in these depositions. We're not.
Well, we will cover motions for summary judgment, because then you will
Yeah,
know.
and then that's different. That's
Right.
different because then we could glean some things that were said in depositions. But in terms of, if you guys are under the impression that we're going to be privy to the discovery in the civil case, it's not going to be it's not going to be what you're thinking. If that's what you're thinking, it's not going to be that. Deps are going to be going on for years, years in that case, and we're not going to be privy to them. Unless, like what Allie's saying, if there's a motion to dismiss or if there's a motion for summary judgment, which I'm sure are going to be numerous in this case, but that thing is years away from going to trial. Years. Yes, we are digressing a lot today.
All right. We digress. Thank you.
Pathway to violence model has never been evaluated. Anyone who would say, here's what I think, they're just guessing on how often someone would actually go on to commit violence.
Let me ask you, tell me if I'm wrong. When I was looking at the pathway to violence, it appeared that the purpose of it was to try and help identify mass shooters, school shooters. Why has this been put together? For what purpose, if it doesn't actually ever predict who will go forward to commit a violent act?
I'm telling you guys, if we were able to predict with any level of accuracy who was going to become a school shooter or a mass shooter, we would have a much better situation in our world right now. Again, even with accurate data, like we're collecting, looking at this, putting very sophisticated predictive models together, we are so unable to predict the violence, school violence, these targeted violence offenses, and domestic violence is even harder to predict. As our judge mentioned earlier, the vast majority of them are emotional. They're not these, long premeditated, thought out things. So the emotional dynamic factors actually have a much higher predictive validity than any type of long-term grievance, at least based on research. If we were able to do this, I would feel much better about my young son, going to school soon. I'm terrified because we are so bad at it. Even from a magnet, huge amounts of money being spent on this type of research, we are still unable to do it with any type of reasonable accuracy, because finding that needle in a haystack, someone who meets all of these criteria but is actually going to commit violence, is so hard to do.
Let me ask you, just for sake of argument, if we were to assume that the pathway for violence had some reliability in the area of mass shooting and school shooting, was it meant to be applied in this sort of case?
Oh, no. And that's actually, again, something I talk about in
There we
my
go.
undergraduate courses. We have this
Right there.
problem, it's like mission creep. We think, because it applies here, it can apply over here. And that's absolutely not the case. A domestic violence type of scenario, poisoning, they're so fundamentally different in the way those two things are committed, played out. Applying something that is, even without data, created for the purposes of these targeted attacks that do engage in more radicalization behaviors. You applying that to something that's statistically more emotionally driven,
Apples to oranges,
that
baby.
would be very inappropriate.
All right. So just to wrap up, in your expert opinion, should the pathway to violence be admitted as scientifically reliable evidence the jury can rely on?
Yes.
No,
Don't call it
absolutely not.
scientific. Call it
If
specialized
we're basing
knowledge.
this on reliability, if we're basing it on, how using it to know that this is scientifically valid,
I would
absolutely not.
love to see if the judge
The
has questions.
logical fallacies that are endemic to this, the huge amounts of unknowns, like how often it's wrong, which would be far more wrong than right. It's akin to like the Barnum effect at circuses, or like psychics. That would be the closest I would say in terms of how accurate and valid and applicable this would be to an individual case.
I have nothing further.
Ms. Shervnak, do you have any questions for Ms. Fox?
I do not.
Ms. Fox,
do
may I
not.
ask you just a couple of basic questions?
Yes.
Surely.
Love it.
You went through the FBI Academy at Quantico.
Yes, I did.
Were the pathways to violence taught as part of that curriculum?
No, it wasn't.
Did you have exposure to this during your career in the FBI?
No, I wasn't. There are these, similar models, like, I think they call it like pathways to radicalization. And I just learned about that. And again, like while I was in the BSU, that was one of the things that I was brought on to try to revamp and improve.
Okay, thank you. Ms. Lewis, anything further?
No, Your Honor.
Okay. Ms. Shervnak, anything for Dr. Fox? Okay. Thank you, Dr. Fox. You're welcome to stay connected, but you're also welcome to turn off your video and audio.
Thank you.
Ms. Lewis, do you want to ask any questions of Ms. Amon?
Are you not going to put Ms. Amon? Is the state going to put Ms. Amon on, or only if I have questions? I guess would be
Ms. Shervnak, are you relying on her proffer, or do you want to elicit some testimony from her?
I'll elicit some testimony from her.
Okay. Ms. Amon, do you mind turning on your video and audio?
So here's the
May I
state's
swear you in, please?
expert that's going to
Do
say.
you swear that the testimony you give today
Catholic
will be the truth,
violence
the
is
whole
good.
truth, and nothing but the truth under the pains and penalties of perjury?
I do.
All right.
Good morning, Ms. Amon.
Good morning.
Your Honor, before I begin with her testimony, Ms. Amon's CV lays out her qualifications. The state's
Pause it
position is
real
that
quick,
she possesses
babe.
the requisite knowledge, training, experience, education.
I think the defense missed a great opportunity to go first there because the judge was taking issue with. So when you weren't here, this very lawyer, are they state's attorneys or district attorneys in Utah? Whatever. This prosecutor stood up and told the judge that she's going to testify that everyone who commits the ultimate act at the end has the attributes or the characteristics or whatever the hell this pathway to violence sets out. And in all of the people do, and it happens every time. And the judge is like, whoa, 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 wait a minute. Happens every time, all of them. If she's going to get up and say that, that's a problem. Now, if she's going to say sometimes, often, most times, I think he actually used most times, then I'd be okay. And the lawyer was like, oh, yeah, I mean, things like every and all are an extreme. So the defense, by being like, well, wait a minute, why am I asking her questions first? Just, might have shot themselves in the foot in a way to ask her a question that doesn't fix that problem and maybe brings it out more, like by getting her to say it first. So all of the people that, commit the ultimate offense have these, and she says yes, then there you go.
Yeah. I mean, are you surprised at all that the state didn't cross that particular witness?
I mean, I'm a little surprised, but not too much because
I mean, they weren't going to get any movement.
no, they weren't going to get any movement.
That's for sure.
And they're hoping that the judge is going to say, I mean, I wish that the defense would have said, is it specialized knowledge that would be helpful to the jury, but I think the judge can figure that out on his own because that's what the judge keeps saying. We're not saying it's scientific evidence. We're saying it's specialized knowledge.
Yeah.
So,
Okay.
Specialized hunches.
to satisfy 702A. If the court sees it differently, I'm happy to ask her some of those questions, but I prefer to focus my questions directly elsewhere. If that
I
makes sense.
agree that her CV reflects that she has sufficient education, training, and experience to qualify under 702A as an expert in her field.
Thank you, Your Honor. So, Ms. Amon, I don't think we need to go through all of the steps of the pathway to violence. I think the court has the generalized view of it, but what I would like to ask you are a few questions about how this model was developed, and we'll start there.
Sure.
Because were you there like the other woman? That's what I
So in
wanna
terms
know.
of how the model was developed, you'd have to, I guess, go back. The scientific research leading up to where we are now started about 100 years ago, give or take, when researchers began studying aggression in mammals. Specifically cats were the sort of the origin story of this line of research. And researchers noticed two distinct patterns of aggression in cats depending on the circumstances. In some studies, cats were presented with a threatening stimulus, a very threatening stimulus. And in those cases, they demonstrated intense autonomic arousal. So arched back, fluffed tail, hair along the midline, standing on end, that's called piloerection, pinned back ears. They localized, such as hissing and growling, fangs out, claws bared, the whole show. You can sort of think of it as that classic Halloween decoration of the scaredy cat with the arched back and all that. And they very quickly lashed out with an emotionally charged and relatively uncontrolled attack with paws and claws. And that was labeled affective violence. It's affective for the psychological term affect, meaning sort of the state of thinking or emoting or feeling emotions. And then in other studies, the cats were presented with prey, like a mouse. And that was a totally different story. The cats were low to the ground, completely silent. Ears, instead of pinned back, they were open to localized sound, and the cats would inch forward, and they appeared to be planning and carrying out an attack at the moment of their choosing, typically with a bite to the neck or head, a very efficient biting attack that ended the fight really before it began. And over the next several decades, that line of research expanded to other mammals, including humans. And what they discovered was that not only do these behavioral patterns hold true in humans, but they're also biologically distinct from one another. And the understanding came now that affective violence, so that reactive attack, is triggered by lower brain structures in the limbic system, triggering an intense autonomic arousal, as I've discussed, usually accompanied by intense fear or anger, and a cascade of hormones, all culminating in a sudden physical defense against imminent threat, which could be real or perceived. It could be an internalized threat. And the evolutionary basis for that in humans is survival. So if you were an early human out on the savannah, there was really no time to ponder whether that movement in the bush was caused by the wind or a predator. The early humans who acted quickly were the ones who survived. In terms of predatory violence, we now understand that to be characterized by a lack of autonomic arousal or emotional experience and no perception of a threat. And that lack of stimulation allows for higher cortical activity in the brain to choreograph an attack that meets the attacker's goals, whatever those goals may be. And the evolutionary basis for that in humans is hunting for food. So early humans on the savannah who hunted with minimal autonomic arousal, no anger or fear, were better able to engage higher brain functions to plan and prepare in advance, and therefore were likely to return with food for their offspring. Those who could not or did not do that were less likely to survive and pass on their genes. And we know that humans, like none of us would be here right now if our ancestors didn't have the capacity for both of those types of violence. So fast forward to now, there have been studies on neurochemicals and hormones, neuroanatomical brain scans with PET and MRI, to look at the differences between these two modes of violence, and all of them support the bimodal nature of violence. So that research evolved more or less concurrently with behavioral studies that were going on in the 80s and 90s on attacks against celebrities, judges, governmental figures, and some others, all of which led to a very clear conclusion that intended violence is a process composed of discrete, sequential, and recognizable behaviors. And the pathway to violence model came into being at the conclusion of that time frame based on the biological data and the behavioral observation data from all of the studies, many studies. So that's kind of a 10,000 foot view of the science in terms of how we got to where we are now.
So how is the pathway to violence used in the behavioral analysis community?
We use it not to predict, but to prevent. And that's a very clear distinction that needs to be made. Prediction is not possible. We don't talk about predicting human behavior. We talk about preventing it. I would liken it to if, let's say, I'm your cardiologist and you came to me and you were very overweight, sedentary, hypertensive, you had high serum cholesterol, you had bacon for every meal, and you were super stressed out. As your cardiologist, I couldn't tell you that you're going to have a heart attack next Tuesday morning at 9:24 a.m. But what I can tell you is that you're at heightened risk for a cardiac event, and we need to manage your condition with lifestyle changes and probably some medication to lower that risk. That's how we work in behavioral threat assessment, and the pathway is part of that. It's only applied in cases where where someone has already presented themselves to authorities, to whoever, as raising concerns for violence. So the person is doing something that has brought concerns of violence to the table. Whoever's bringing us the case, maybe it's a school district, maybe it's a workplace, isn't sure what to do, we would begin to look at the behaviors the person is demonstrating, and our being on the lookout for possible pathway behaviors is one of the things that we would do. It's actually considered one of one of 8 proximal warning behaviors that we would look at to decide if this person needs a deeper look. So it's a tool. It's one of many tools we use. It's certainly been subject of many studies in terms of whether or not it's valid for measuring what we want to measure. That is behaviors that raise for us concern about whether or not violence might be on the horizon.
And is the pathway to violence utilized, or could it be utilized in instances of targeted violence that only include one individual as the target?
Oh, certainly. Targeted violence is targeted violence. They all share behavioral commonalities, particularly where the pathway is concerned. If you understand the nature of the items on the pathway, then you also understand that the majority of them are steps that most targeted violence offenders would pass through. Whether you're planning to kill 100 people or one person, you still have to make the decision to do it. You still have to engage in some planning, some preparation, even if it's very, very simple. Some people require a lot of planning and preparation. Some people require very little to get to a state of readiness. But it doesn't really matter what the size of the targeting is. That's not relevant. What's relevant is that certain behaviors must occur in most cases in order to get someone to a state of readiness to engage in planned violence. I'm not talking about unplanned violence or affective violence. That's not really relevant here. But most people will have to pass through some of those stages, if not all.
Is the pathway to violence model generally accepted in the behavioral analysis or behavioral science community?
Absolutely. It's completely foundational to what we do. I know of no learned and credible threat assessment professionals who don't believe in the pathway. It's at the foundation of what we do. It's included in virtually every aspect of what we consider the body of knowledge in behavioral threat assessment, which I used to administer. I'm a former chair of this national certification program in this discipline, and the pathway is very foundational.
And is that something that you would describe as currently used, or is this a past a model that was used in the past, or is it a currently used model?
Currently used. Up until about 2012 or so, it was kind of it was the name of the game. It was the pathway. And then right around 2012, we had the realization that it's but one of 8 proximal warning behaviors, proximal meaning close in time to potential act of violence. And so now we tend to look at pathway as one of those 8. So in terms of more recent studies, in terms of its validation, it's the proximal warning behaviors that we look at. We don't usually use the word pathway necessarily on its own, but it is a discrete behavior as part of the 8 proximal warning behaviors. But it's absolutely used now. It's very, very important to what we do.
And now, if you could explain the retrospective analysis and why prospective analysis is not feasible.
Sure. All the studies on pathway and proximal warning behaviors are retrospective. In fact, someone asked me at a conference the other day, where are we on prospective research? And my answer was nowhere. We can't do it. So retrospective analysis is looking backward at cases with a known result, so violence. So let's say I want to look at a single person homicide in a workplace. I would look backwards at the completed event, knowing that it had the result that I'm interested in, violence. And then I would look for what patterns of behavior can I identify that did occur leading up to the violent event, and then code those. And so I would know that those occurred. So a retrospective study would have a sample of cases and then look backward in time and code the behaviors that we know to have occurred. And that helps us to understand what are the commonalities. You can't, Dr. Fox is absolutely correct that those studies can't be used for prediction. They're not predictive validity studies, but what they do is validate the measure as measuring what we intended to measure. Prospective is, you would need a prospective study to truly call something predictive, but to do a prospective study in violence would be to have a case of concern, and then look for what you believe to be pathway behaviors. And once you've identified them, it would require you to sit back and do nothing and allow violence to unfold and then code your data, which is horrible to even think about. None of us would ever do that. So we use retrospective analysis, and it's widely acceptable in the behavioral sciences as a research strategy.
Thank you. Just a moment. Those are my questions for you at the moment. Thank you, Ms. Annan.
Well,
See if she gives her the business.
the judge is going to say it goes to wait. You got two completely diametrical.
Yeah.
Just a moment.
I don't know that
Good morning,
that cat
Good
thing
morning.
now.
So Ms. Sherbanek asked you how the model was developed, and you told us about cat
A
research,
cat.
but I didn't hear an answer as to how the model was actually developed.
Sure. So in the 80s or 90s, a number of studies were conducted on attacks against public figures, political figures, judges, other people. And in those studies, it became quite clear that the offenders were typically engaging in a sequential and recognizable cascade of behaviors leading to the violent attack. And so that became the pathway to violence. The data collected from those studies showed that 6 particular discrete stages were happening in virtually every case that was studied back at that time. And so
Virtually
that became the
every.
pathway to violence. Does that answer your question?
A little bit. So, but the pathway to violence talks about, strike that. Let me rephrase. So you used the analogy of a cardiologist. You said this isn't predictive, it's preventive.
Right.
Right?
Right.
So this only applies after an event has happened?
No, not at all. That's how we have studied it. How we use it is in advance. So let's say, for example, you are a school principal and a child in your school has risen to your attention as raising concerns for violence for whatever reason. Maybe he's got a hit list, maybe he's stalking his girlfriend. So I would look at that if I were consulting with you, and I would ask for everything you know about the situation and the child. And I would look for evidence of these 8 proximal warning behaviors primarily that we know to be well correlated with subsequent violence, including the pathway. And if I saw evidence of any of those, then I would advocate for active management of the case to
Know
try
what?
to reduce the violence risk. The general
Pause it
rule
real
is that
quick.
once you observe 1 or more of the proximal warning behaviors, then some sort of
And you minimize it. Yeah. I meant to say this from when I was listening to the direct. Sounds to me like this is the pathways is one piece of an 8-piece puzzle. You know, like they don't use it in isolation. That might be, a better argument, but I don't know that this woman's testimony would be limited to the pathways, I don't know.
The pathways to violence.
Yeah, it sounds like a soap opera.
Sounds like something. I don't know what it sounds like.
Active management is necessary to prevent violence. So we're managing behaviors of concern in the present to prevent violence in the future. We don't know that the child is ever going to be violent, but we're not waiting around to find out. We're going to take active steps to try to prevent and manage.
And you have no idea if absent those active steps, would that child ever have committed violence, true?
No idea is a bit strong, but do we know? No, we don't know. That's correct. Someone can certainly ride the pathway all the way up to one of the upper steps and then never do a thing. That's entirely possible.
All right. So you talked about that it has been subject to many studies. Could you tell me what studies this has been subject to?
Sure. Yeah, I was a little bit surprised to hear Dr. Fox say that it has been subject to no studies. The most recent study that was specifically on the pathway and only pathway came out in 2024 in the Journal of Threat Assessment and Management. And they had a very high, actually high inter-rater reliability score in that study. I would say the majority of studies in the last decade are more on proximal warning behaviors is the label that you would have to search by rather than pathway. They're on, almost more than I can count, but public figures, mass attackers, intimate partner homicide offenders, other sorts of family offenders like paternal filicide, maternal filicide, that kind of thing. Workplace, classroom. The journals are really littered with studies looking at proximal warning behaviors.
So is she testifying about proximate warning
studies
behaviors
that you can point to that
pathways?
adopt this?
All peer-reviewed studies, all of them.
What are they?
Well, I supplied a list to Ms. Chevernak when they first contacted me, but the most recent one that I mentioned in 2024 is called "Are All Pathway Behaviors Observable? A Quantitative Analysis of the Pathway to Intended Violence Model." And that came out in the Journal of Threat Assessment and Management.
So the same one you just told me about?
Yes.
Okay. All right, so it's not a predictive model, it's a preventive model.
Right.
It's not capable, you can't generate any numerical score, correct?
No.
Using this. And it's not designed to determine if a specific individual is going to commit violence, correct?
No, I agree with Dr. Fox's description that it's a descriptive model. It describes behaviors that have been observed in studies. I would say its operational use is not in prediction, but in prevention, which I think is really a key difference in terms of how we use it in the field.
So it could be useful if someone came to the FBI and said they're thinking about a mass shooting.
I'm not sure I take your meaning.
Well,
Me
if it's
neither.
not useful in predicting violence, and it's useful, as you said in your cardiology example, if someone comes in and says, hey, I'm having these symptoms, then, you can help prevent it. So how is this at all useful in the real world? Because people don't come into the FBI and say, I'm having these symptoms, and you can say, well, you are on the pathway to violence, let me help you. That doesn't happen, correct?
Yeah, that's never happened as far as I know, but how it is used is...
You are on the pathway to violence. You should get that checked.
If I'm looking at a case where someone has already risen to the attention of whoever is observing as someone being of concern for violence, maybe they've been making threats, maybe they've been menacing people, maybe they have a hit list, whatever, that can look a million different ways. Then I look at the entirety of the case, as many facts as can be gathered, and then I begin looking for signs of proximal warning behaviors to decide if we're in, sort of an imminent countdown potentially to an act of violence. And that's where the pathway to violence becomes quite useful. If I observe someone on the pathway, particularly in late stage pathway markers, then I might develop, depending on the context, I'd have a lot of questions, but I might become...
Late stage pathway markers. You say you drafted a walk the dog letter. Well, that is a marker on the pathway towards violence.
Well, that's
Very
post, but
concerned
you know.
that we're close to
Oh,
a potential
sorry.
act of violence.
Has this ever actually happened in the real world?
The
Where
way I
you
just
have
described it?
stopped violence based on something that was brought to your attention?
Well,
How can you
we've
say
had
that that has happened?
we can't. That's what I mean by there's no prediction. I can't. So when we see pathway behaviors or other proximal warning behaviors, we intervene. That's our job, is to intervene. So once we've intervened and there's no violence, how can we ever say that there would have been violence but for intervention? You can't. You can't prove what never happened.
All right. It's fair to say that two evaluators could look at an individual and reach completely different conclusions, whether someone's on the pathway to violence or not, right?
Not well-trained evaluators.
So your testimony is that people always come to the same conclusion if they're trained in this?
No.
Okay. So people can come to different conclusions even if they're all both well-trained people.
I think if they're well-trained, they should not come to different conclusions on something as fundamental as the pathway. You
But
can come to different conclusions about how close someone is to violence.
But it's subjective, right? It's not based on scientific data.
Well, it is based on scientific data. All those studies that I referenced in the 80s and 90s that helped Brian Foskule, Randy Vorum, and Robert Fine arrive at the pathway to violence. That's data.
The journal we talked about that it was published in.
No, that's a different journal. There are dozens of studies, but we're talking about the study I referred you to was in 2024,
Okay.
just because it's the most recent one, specifically on the pathway and only the pathway. But the journals I'm talking about we're talking like 80s and 90s.
There's no way that the model can tell us how often it produces false positives, right?
Correct.
And you can't tell us the model's error rate. True.
Correct.
You can't quantify the likelihood that an individual identified as being on the pathway will not commit violence.
I can't quantify whether they will or will not. It doesn't work that way.
Yet you
What
believe
the
you could.
fuck is the pathway anyway?
I don't know anything about this case, actually.
Well, you know what the defendant's charged with.
I believe it's a homicide, but I don't know any facts and circumstances or if there are other charges.
Okay.
Wait, what?
Are you familiar with the case United States versus Wells?
So the state has a
It's supposed to be a blind expert who doesn't know it so that she can tell the jury, I know nothing about this case. So I'm not in any way, shape, or form trying to say it applies here. I'm just giving you the stuff and you guys can determine if it applies here.
hey, Miss
Right.
Janet, good to see you.
And I think they find that to be less prejudicial because the person's not even attempting to say it's applicable in this case.
Yeah, I mean, you're, I guess, theoretically avoiding bias.
And I think that's why she's not asking the question. Maybe she can wait some time and give out a bunch of different scenarios to see how she responds and throw poisoning in.
So I just I want to be clear. So 3 dudes sat in a room in the 70s and 80s and watched a bunch of cats fuck around, and then they came up with pathways to
No.
violence. Is that what happened here? I think that's what happened. I think
What
that's
I was trying
exactly
to
what
figure
happened.
out is how in the fuck do they know what the success rate of first people, hunters were and what contributed to that success rate? How could they possibly study that? How could they possibly make a scientific conclusion about it? Maybe it was the guy who was so hyped up, everything got him going, Hyperman, and he was the one that survived because he was faster and more sporadic. And I mean, this whole thing that, well, the people that stayed calm and used their brain and thought things out were much more successful at hunting. What about the
Ma'am,
guy that just did
ma'am,
the
are you
off the
questioning our theory?
off
Well,
the
that is
cuff
a marker
shit?
on the pathway to violence.
He did
I will tell
off
you that.
he did crazy shit and got lucky every fucking time.
I mean,
Sure, it makes sense. Whoever's using their brain more is gonna do what? I don't know, dude. Sounds crazy.
that's crazy.
All of it is theory. All of it is theory.
Yeah.
All
And it's
of
like, and despite what this witness has said, that there was data behind it. What data? Well, they said things.
Well,
So
no, she's saying
what?
that
No.
that they did interviews of people who there was evidence and cases of people who actually committed violence. I don't know what the damn 8 steps are, but one of them sounds like it's like preparing. So they're like, okay, this guy prepared. That's definitely, I think, a step. I don't know what the other ones are, but I think what she was saying is they knew that it occurred in
I
that
want to go
case.
back and apply the pathways of violence to Brian Walsh's behavior leading up to that fatal night. We'll see if it fits. We'll see if it fits. We'll be right back. Allie and I are going to go do that, and we'll let you know if the pathway to violence is in fact legit.
I am not.
Kidding. We're not doing that.
Isn't Agent Malloy a colleague of yours who helped write the Pathway to Violence?
Agent Malloy? Oh, Dr. Reed Malloy? He's not an agent. He didn't write the Pathway to Violence, nor did I.
So you're not aware, you
Dr.
gave the
Reed
example
from
of
Criminal Minds?
workplace shooting.
BAU?
Okay.
So you're not aware that that is the exact case that was rejected as the science being unreliable in the United States versus Wells. You're not aware of that.
I'm sorry. I have no idea what you're talking about.
All right.
Court has
Have you
said it's
testified in a
junk.
homicide trial about the pathway to violence previously?
I have not.
Have you testified as an expert previously?
I have not.
She's like, damn, I should have challenged that expert.
Can you give me any examples where the pathway to violence was used in the courtroom at a homicide trial after the fact?
I don't know.
Okay. I have nothing further.
This shit ain't used. This shit ain't used, Your Honor.
You sure we don't have anything further?
No.
Okay. Ms.
Questions?
Ammon,
Gotcha.
thank you. You're
Gotcha.
welcome
No
to
questions.
turn off your video and your camera. Why don't we take a 10-minute break and then we'll come back. Thank you. Come back at 11:10. Thank you.
I need to go back in my chambers and just laugh and laugh and laugh and laugh. And then I'll be back to give my ruling on this particular issue. All right. So there we go. We got, we might actually have 10 minutes of blooping with all of our
Yes.
digressions.
Yes. The great
So-
digression.
All right. So yeah, I went back while we were watching and I did watch the 2 preceding scenes and he definitely is saying Brett.
Yep. You better text your friend Jill because you guys both use that one a lot.
Well, I mean, in the line, like Sam Jackson fucked up. He's definitely saying Brad because when he says Brett in the other 2 lines, it's clear as a bell.
Yeah. He just, bloop. We're done
All right,
with
let's
talking about
blooping.
it.
I found it to be a fascinating conversation.
I did too.
It
What?
was ranking right up there with the pathway to violence. I found them to be equally fascinating conversations. Do-do-do-do. Oh yeah, baby.
Hey-o.
Blooping. Can we have a round of applause for blooping, please? Let's get a round of applause for the bloops.
See how I did it round like?
Okay, hold on.
It was hard with my shoulder, but I did it.
Area where we see this happening.
Wait,
But
what?
it wasn't an expert witness exactly. It was a detective who was testifying based upon experience. And based on his experience, he said that in all his years as being whatever kind of agent he was in drug cases, he always saw this same profile of drug couriers.
I think he said most, didn't he? Isn't that the distinction?
It might have been, I don't know if it was all or most. It was most all.
Key part of the case is that he said most, and that's how Justice Thomas said, well, that's not impermissible under 704B because
That's
it
why-
acknowledges that there are some outside of most.
So I'm assuming she took a peep at Diaz, and that's what
Maybe, but this is exactly what I was saying earlier. She missed the boat to ask this woman if of all of the cases that their data relies on, where they know the violence occurred at the end, is she testifying that every one of them were on the pathway to yes. At all times, yes, because if that's what she said, the judge wasn't letting it in. He made that abundantly clear. And the fact that she just stood up and didn't know whether they said most or all when the judge already said This is why paying attention in a courtroom is important, but it's a lot easier to do when you're not the lawyer. Your mind's not racing on all the other things you have to present. You're not thinking, like about the next thing you have to do. But
Or what you're going to question the witness on, like
right.
as she's testifying and you're jotting something down and you miss the last thing she said. I mean, it's challenging. So I'm mildly irritated that Law and Crime didn't get back in time and we missed kind of the beginning of this.
Yeah.
I'm gonna bloop it back. So
That's
we
it.
clearly missed some of the beginning of the so Birdman 1980, listening to Auntie Bev in the sidebars leads me on a pathway to vengeance and furious anger. Thank you for that. Thank you for the tip of the cap to Pulp Fiction, which was obviously the main focus of my digression that led me to all you guys thinking I was sleeping. Dude, Birdman, as furious as you are with Auntie Bev, why don't you go back and watch some of our coverage of Judge Gull in the Richard Allen case? It's like Judge Bev was like the pinnacle of judges in comparison to Judge Gull. There is just no comparison between the two judges.
Like,
And
if
as
you're using
awful
it as a bar, even if we put Bev down here,
right,
Gull is way further below
she's
her.
like in the depths of hell,
In the depths of hell.
swimming in lava pools.
Talk about vengeance
Cackling.
and furious anger.
Furious anger. All right.
That'll do it.
That'll do it. All right. So I just wanted to prove that we didn't miss anything, that this was clearly a Law and Crime thing.
Yeah, fuckers.
Sons of
But
bitches.
don't they know? Just go to the ceiling. Give us the equivalent to OnlyFan.
Only fan, only drop tile. All right, here we go.
Right.
Area where we see this happening. But it wasn't an expert witness exactly. It was a detective who was testifying based upon experience. And based on his experience, he said that in, all his years as being whatever kind of agent he was in drug cases, he always saw this same profile of drug couriers.
I think he said most, didn't he? Isn't that the distinction?
It might have been, I don't know if it was all or most. It was most all.
The key part of the case is that he said most, and that's how Justice Thomas said, well, that's not impermissible under 704B because it acknowledges that there are some outside of most who don't know.
Either way, it's different because he was an experienced witness, not an expert witness. And in this case, Ms. Amon is not an experienced witness. She didn't write this. She hasn't
experienced it.
She can't get up there and say what the detective said in that case because for a number of reasons. Other people did the studies.
May I cut to the chase a little bit here to see if we see it the same way?
Yes,
I
Judge, I love when you do this.
With the defense that under cases like United States versus Wells, the expert testimony that Ms. Amon offers cannot be used in the state's case in chief and cannot be used in any part of the case as substantive evidence of defendant's guilt. Here, though, the issue, based on the briefing, is more nuanced. It seems to me that the state could use Ms. Amon's expert testimony in its rebuttal case and only to rebut a general categorical assertion by the defendant in her defense case that this is simply not how it works. This is not credible that someone would engage in a weeks-long campaign to kill someone in the absence of an imminent threat to their life or some kind of emotional or extreme impetus. If there's that kind of categorical generalized argument made by the defense, then I think this testimony from Ms. Amon, which is based upon a retrospective study of killings that actually occurred, saying in the retrospective study of killings that actually occurred, people did plan them over a varying level of time, and there were steps they took along the way. As long as the prosecution did not turn the corner in closing argument to say,
Couldn't he have just given to us, instead of saying along the way, just said pathway? Why didn't he do it? Come on, Judge.
well, we showed you elements of plan and preparation on behalf of Ms. Richins. You heard Ms. Amon, so that shows it's more likely than not that Ms. Richins killed her husband. They can't do that in closing. That would be using an inappropriate profile-like argument. But to rebut a categorical, generalized statement from the defense,
How are they
that
ever
this is
making
simply
that?
not the way homicide works, I think that would be helpful to the trier of fact under 702A. Tell me why not.
Well, first of all,
That's not happening.
this would be the first time that it's ever used that way. You heard Ms. Amon, this has never been used.
Well, that
in-
may be because it'd be the first time that a defense has ever made that kind of argument, but I'm not sure we're going to have to cross that bridge here.
Well,
Are
we
you-
may not. But I think it's never been used because it's not reliable. The study wasn't made even though to pick out individuals who commit violence. It was developed, she said, the only time.
Why
They're
does that
not
matter?
using it predictive
Right.
in my hypothetical.
Why do you
They're
keep
only
saying
using
that?
it to rebut a generalized statement of murders don't get planned like this.
Well, it can't be used predictive. I think that was pretty clear.
Right.
It's
I'm agreeing
not.
with you on that. We're
Yeah.
past that.
All right.
Correct.
So my point is that
Focus on what matters, lady.
when she talked about individuals, though, she talked about how the study applied to assassinations. The study was not developed in any way, shape, or form to look at this sort of instance.
She said,
Let's be careful here. I think there's a side of the V that would call this an assassination of a non-political figure, but nonetheless, stay focused with me. Why wouldn't that be helpful to the trier of fact under 702A to understand sometimes killings are targeted? We know because we've studied killings that have actually occurred. Sometimes they're planned. Sometimes they take time for that plan to develop.
Are
I
you
guess I
s-
don't understand how that's helpful. Yes, I don't isn't that general knowledge that sometimes killings are planned? I don't
I don't
understand.
know if it is or not, but it's
Where-
that would be like if the defense is going to make the argument, these
Are
things are
you?
never planned. This is simply not the way it works. Now, I don't know if you're going to make that argument, but you're asking me to exclude Ms. Amon under any.
Well, in light of your ruling, there's no way in hell I'm making that argument if you're going to allow this shit to come out.
right. And he keeps saying a categorical. He's not preventing them from saying, you know, I mean, I guess it depends. I don't know what they're planning on having their experts say.
Well, I mean, while I don't love the defense attorney's response, I mean, she's correct. I mean, that is common knowledge. I mean, obviously, some people fucking plan murders.
Yeah, that's why I'm
Yeah.
saying we need the other peers on the
And then
pathway.
the other 7 markers of the pathway, the other parts of the to me, to put on
Amanda.
somebody who's, got their tentacles like dipping in the FBI or the BAU, and they sound to be a person with some kind of gravitas in terms of what they do for a living, getting them on the stand, like jurors give that shit weight.
Well, that's why they don't let that in. They don't let the BAU get up and say
I
the
know.
people that commit this, they're males between this, but they're not allowed to give their profiles ever.
And
know?
this seems like the equivalent.
Well, but that's why
Without-
he keeps
without-
focusing on if you're gonna say murders don't happen like this. I still don't know what.
Okay, well, what does he do? So say the defense doesn't. Okay, so here's the workaround for the defense. Okay, don't have any of your experts bring it up. Don't ask the question, and then in closing, argue it that like the murders don't happen like that. I mean, then you circumvent this whole
Well, I think
cat-
they'd shut you down if you did that in closing when it was the
cat
whole.
way. What it's argument. It's common knowledge. I don't know. It's a weird issue.
Circumstance, and I'm not sure you've carried that water.
Well, we're asking that she be excluded because it's under I'm going to move also under 403 and 404B. It's highly prejudicial for someone to get up there and tell a jury, I'm an expert, and it's, if we were to make that argument, which I don't know, let's say we were to make the argument, she's a mother, she wouldn't have killed the father of her children. How prejudicial is it for someone to get up who claims they're an expert, who's not an expert, never has testified, never has used the study in this way, and then tell a jury why we're wrong?
Yeah, but
that-
you changed my hypothetical.
Right.
Ms. Amon doesn't comment
mine
in any,
better.
Wait, no,
in any
listen.
way on the specifics of one mother killing her husband or the father of her children. I'm not suggesting you can't make the argument that Kouri Richins had so much to lose by doing this, it reduces the likelihood that she did it.
But that opens the door for Ms.
No.
Amon to come in under your hypothetical.
No.
because
It does not.
no, that could happen.
Please stay focused.
Okay.
A
Oh.
general, absolute, categorical statement by defendant. Murder doesn't happen this way.
Amanda.
They're always emotional. They're always in response to a threat. They're always as part of a fight or as part of a criminal enterprise. I don't know what you'd say, but if you want me to exclude her entirely, I'd have to say that there is no set of circumstances in this case under which her testimony would be helpful to the trier of fact, and you haven't carried that burden.
So you're saying that in
Categorical,
your view,
woman.
the only way her testimony could be relevant is if the defense says
Always.
this
Don't
kind
use
of
the word
murder would
always.
only happen
Or
in
only.
a enraged emotional state
Yeah, or in response to a threat.
or in response to a threat. That's the
Right.
only way this is coming in.
That seems to be correct. Tell me why that isn't correct.
Well, I don't know that we really even have a problem if that's the court's
Thank
ruling. That it's only
you.
coming in under one specific circumstance. I just think about
Well-
our general objection, though, is
Only or
is
always.
just not reliable under
Never
702
use
under
those
any
words.
circumstance. It doesn't matter what the circumstance is. I think that
This is why I'm not persuaded by that. The defense keeps, at least implicitly, taking the position that if two people could apply this framework and reach different conclusions, it's not scientific, it's not reliable. Is that one of the defense arguments?
well, one of many.
Sure.
It's not.
Now, that would mean that every physician that testifies in a medical malpractice case is unreliable, because in every single medical malpractice case, there are competing expert testimonies regarding the standard of care and whether it was breached.
Well-
And they're both admissible, and it all goes to weight, not admissibility.
I thought about that as I was listening to her testimony. And I think the difference is, and I don't do medical malpractice, but I think the difference is when we have competing medical experts, it's typically based on actual scientific research and knowledge. And
Or
they
their
might have
education,
different,
training, and experience. They're not citing studies most of the time.
but it's based in science. You can get two experts who have a different opinion when they apply the science, but this isn't any applied science of any kind. This is just a completely subjective theory.
But the law enforcement expert in Diaz wasn't applying science either, but he was offering specialized education, training, and experience. That's the subject of Rule 702.
Well, he was not an expert, that's true, but he was
In Utah,
applying.
he would have to be qualified as one in order to say what he said.
I know we see that in federal court all the time. They're applying their own experience. I am a DEA agent. I have arrested 1,000 drug couriers. Of those 1,000, the vast majority fit these characteristics. That's very different than what Ms. Amon wants to testify to. It's very different.
I think the rigor of Ms. Amon's testimony is greater in terms of, here are the studies. We looked at killings that actually occurred, identified these factors. We've published it. We've added it to the model. This is how we use it, full stop.
But none of those studies, well, first of all, she really didn't tell us what any of those studies were, but
This goes to weight, and Dr. Fox will be able to tell the jury why this isn't going to help you make these
Lady,
decisions.
move
that's
the
correct.
fuck
But if
on,
none of
because
the
you're not
studies
going to make
have to do
this
with the domestic
categorical
violence case, how is that
assertion.
helpful to the trier of fact?
Because if you're going to make a categorical people don't murder people this way statement, it has nothing to do with domestic violence anyway.
And I think one of the other problems is when she stated you can go all the way down the pathway of violence and then they don't commit a murder. So
The
how is
defense is
that even
thick.
helpful?
That increases the reliability of her testimony instead of decreasing it, because it acknowledges that there are people on the pathway that fall.
I mean, no lawyer wants to have a judge tell them not once, but twice to focus and stay with me. But
Because, I mean, he couldn't be more clear. He
right,
keeps saying
I
he just
agree.
said the words, "You know what? The only time this is allowed in is if you make this categorical assertion that murders don't happen this way. So domestic violence doesn't even matter anymore because
Right,
it's murders don't happen this way," which you're never going to say. You
right.
can say all the other things that there was no immediate threat. There was no this, there was no that. I think you can also say, and maybe she needs to clear it up if we talk about, I mean, he said categorical. So I would just clear up. So even if the expert speaks to, in most cases seeing X, Y, and Z and does not make a categorical, claim, that still doesn't come in. And I think his answer is yes, correct. It still doesn't come in. It's got to be a categorical. This never happens. Not even most of the times these things occur. As long as they don't say it never happens under these other circumstances.
Yeah. I and she seemed to acknowledge that she understood that. And she
Yeah.
said, "Oh, well, as long as it's limited to categorical assertions made by us, I think we can avoid that." Like, the discussion ends there. Just sit down. It's like, at this point, we're beating the dead horse. He's not
Yeah.
going to change his mind. And frankly, it's not that worrisome.
Right.
Like
He's not going to
he's
change
not
it.
cutting the legs out from under the defense in terms of
No.
how they can posit Kouri Richins' scenario.
Right.
Like, he's said it flat out. I'm not stopping you from saying, oh, that, this is a mother, and getting into the facts of this case.
There was no threat. As long as they use the word most of the time and don't say categorically, then this isn't coming in. Wow.
Yep. All right.
Was that your mouth or the
Yeah,
sound?
that was me. That
Oh.
was me.
Off.
Sounds
So
just like the
most,
sound,
not
though, doesn't
all,
it?
a la Diaz.
Okay.
You're going to want the last word because I think the
All right,
state's going
I'm
to
good,
quibble
yes.
with my ruling here. Ms. Sherman.
Your Honor, I don't know that I have much to add. I think that the type of testimony that Ms. Amon would offer fits squarely within 702. She has specialized knowledge that would assist the trier of fact in making a fact of consequence more or less likely, and that
Nope.
they, being the jury, could use the analytical
Nope.
framework of the pathway to violence.
That's a fucking
taking
big no.
facts that they've heard presented or
Big
theories
no.
that they've heard presented through witnesses and applying them to a framework that Ms. Amon lays out to understand how a person in a position commits a murder under certain circumstances. That testimony assists the jury in understanding
Nope.
how this case could play out, how
If he
it
doesn't know
explains
her,
the theory,
then I don't get it.
or rebuts the theory put forth by the defendant about how this murder was committed and why it was committed. And the jury can use the framework that she presents or wholly discount it if they find it doesn't apply. And that would be up to the jury to decide. But given the type of testimony that Ms. Amon proffered and that we expect her to present as a rebuttal witness, it fits solely within 702. And for those reasons, it's admissible.
Okay. I understand the state's position. Ms. Lewis, anything further?
I guess my last word is just that under 702, I don't see any scenario under which this is a reliable science that could be presented to the jury. And I also don't think the testimony was that the pathway to violence is a most. It's an occasional. It's a few. So I don't think that they're
She's got
to
the
admit this
argument
is
that
reliable under Rule 702 in any matter. I think is inappropriate.
Okay. All right.
nobody listens to me. That's what he's thinking.
All right. The issue before the court is whether Ms. Amon's proffered expert testimony should be excluded in its entirety. The motion is made under Rule 702 and 403 of the Utah Rules of Evidence. The court addresses Rule 702B first. It provides that scientific, technical, or other specialized knowledge may serve as the basis for expert testimony only if there is a threshold showing that the principles or methods that are underlying in the testimony are reliable, are based upon sufficient facts or data, and have been reliably applied to the facts. Here, first, it bears noting that Ms. Amon is being offered as a blind expert. She is speaking about general principles, not applying a framework or analysis to the specific facts of this case. Moreover, her testimony is based upon a retrospective study of killings that actually occurred. And based upon that retrospective study, her testimony identifies some commonalities that exist among completed killings, while also acknowledging that people that begin on the so-called pathway to violence often fall off at any of the stages, sometimes begin again and then fall off again. That just because they begin on the pathway does not predict or mean that they will complete a killing. Under Rule 702A, the court finds that based upon her education, training, and experience, as shown in her CV, Ms. Amon is qualified as an expert in this field. And the court finds that her testimony based upon that retrospective study is sufficiently reliable and based upon a sufficient set of facts or data, given her description of those retrospective studies and their updates over time, to satisfy the minimal threshold for reliability under Rule 702B for a blind expert.
However,
the real issue is whether her testimony would be helpful to the trier of fact under Rule 702A, and under what circumstances. To be clear, under cases like United States versus Wells, 879 F. 3rd 900, which is from the Ninth Circuit in 2018, Ms. Amon's testimony cannot be used by the state in its case in chief as substantive evidence of guilt. And even if she's called as a rebuttal expert, the state cannot refer to her expert testimony as a basis for the jury to draw comparisons that would weigh in favor of a substantive finding of guilt.
exactly what that witch
However,
said. Can't do
in
it.
the event that the defense makes an assertion in its defense case that is categorical and general, for example, something to the effect of that it's simply not credible that a person would engage in a weeks-long campaign to kill another person in the absence of an imminent threat to their safety, then Ms. Amon's testimony regarding the retrospective study of completed killings, showing a feature such as a preparation and plan over time, would be helpful to the trier of fact under Rule 702A to rebut that generalized categorical assertion by the defense. If the defense makes an assertion to the effect of Kouri Richins did not commit these crimes, and one of the reasons you can be sure of that is because Kouri Richins had so much to lose in her personal life and her family life if she had, that is a case-specific level that Ms. Amon's testimony would not be helpful in rebutting. However, if the defense makes a absolute or generalized categorical statement regarding how homicide unfolds or whether it ever unfolds as alleged in this case, Ms. Amon's testimony would be helpful to the trial of fact in rebuttal. And it would not be unfairly prejudicial in a way that substantially outweighs its probative value, because it would not be able to be used by the state as substantive evidence of guilt. Rather, it would only be used to rebut the defendant's categorical assertion regarding features related to homicide. The court acknowledges that pursuant to this ruling, the likelihood that the defendant is going to make such a categorical high-level argument is pretty low, which means that the likelihood that Ms. Ammon will ever be called to testify is also pretty low. But fact remains that there is not a basis to grant defendant's motion in full because there is a cognizable basis upon which her blind expert testimony would be helpful to the trier of fact under Rule 702A, and which its probative value would not be substantially outweighed by the danger of unfair prejudice under Rule 403. So, the defendant's motion to exclude Ms. Ammon's testimony is granted in part and denied in part. She cannot testify in the state's case in chief. The state cannot use her testimony, even if it comes in rebuttal, as substantive evidence of guilt, either directly or by inference. And her testimony would not be helpful to the trier of fact to rebut case-specific assertions of why Kouri Richins did or did not commit the act she's accused of. However, if the defendant makes a categorical assertion regarding how homicides unfold, the court will revisit this issue to determine whether Ms. Ammon's testimony should be allowed in rebuttal. Okay. Pause there for a moment. Ms. Shervinack, do you need any clarification of the court's ruling?
I think she does.
No, Your Honor.
The state does.
Ms. Lewis.
No, Your Honor.
Okay. Ms. Lewis, where would you like to go next?
We do.
Oof.
What do we do, Throckmorton?
Yes, we're Mr. Throckmorton would be
Okay.
next. So Ms. Nestor will be. Do you want to move or are you okay there?
Mr. Throckmorton.
Ms. Nestor, I have looked at Mr. Throckmorton's report from June of 2023 and his amendment in March of 2025. I'm really familiar with him from other cases in terms of his background and his method. Tell me what you see as the problem in this case.
So, Your Honor, can I come to the,
Wherever you're
I
comfortable,
hate bending
please.
over to
Yeah.
reach that microphone.
Gosh.
Yeah,
Mr. Walker.
I just want to. They have litigated the shit out of this case. Like the amount of filings that have been drafted and filed in this case is like Garcia level type shit. Like
Yeah.
there has been a ton of motion work that has taken place. Because I was looking through. Oh, and when we get our next break, I have found a pathway to violence graph that we will be observing, committing to memory, and using for the rest of our lives, all of us.
I got to go get ice, some kind of ice to put on my
Did
shoulder.
you leave the ice maker devoid of water? My
I
friend?
didn't take any ice out of the ice maker. Like it was full when
Because that's why there was no ice in that water I made you, because there was no ice in the ice.
It's weird because I got ice in our live last night, just a couple of cubes because we were out of water. So I was hoping they would melt and it would make more water. And it was full. There was plenty of ice in there.
Interesting.
So the kids were up all night.
Yeah, they
Cameron and
were.
her friends all night.
Like 4 a.m, I heard cackling.
It's 6. They told me good night.
It
And
ripped
I
me
said
out
good
of,
morning.
it ripped me out of some kind of deep slumber. All right, let's go.
May it please the court, good morning. Your Honor, as far as Mr. Throckmorton's testimony, the objections that we
Real quick, everybody just say Throckmorton. Hello, Throckmorton. It's quite a name. It's quite a name. Allie was not impressed with Throckmorton but I am.
Have to his testimony. It's basically focused on the first prong of 702, which is whether or not his testimony can be of any assistance to the finder of fact. And the main concern is his conclusions or lack thereof are basically, I looked at this. I cannot say at all whether Kouri Richins signed Eric Richins' name or didn't. I can't
Right.
say she did. I can't say she didn't.
Right. You skipped a step though.
Right. Well, I'm getting.
I mean, he does say with a much higher level of
Right.
probability
Right.
that Eric Richins didn't sign it.
Right.
He just
So-
can't say that it was with the same level of probability or any, depending on the document,
Right.
that it was Kouri Richins that made the simulated forgeries.
Right. And the concern that we have is his materials that he provided and that we expect would be laid forward before the jury. Take little pictures of letters and compare them. And, you know, all of us are human and we all have eyeballs, and or those of us blessed with a sight have eyeballs that work. And we are tempted to look at those things and compare them and contrast them. And it goes back into a jury room. And the bottom line is they're calling the expert to say, I cannot draw a conclusion that Kouri Richins signed these, signed his name, signed the initials. Even his finding that Eric, I believe the finding he had was a strong probability
For one of them.
that Eric Richins did not initial the documents, not that he didn't sign the power of attorney, but that he didn't even, a strong probability he may not have initialed them, which is not even to the standard of, you know, beyond a reasonable doubt. It's not anything close to that. And the concern that I have is you're taking an expert who is going to basically say, here's all this stuff. I'm going to send this back in the jury room. Y'all can sit there and look at these initials. You can try to figure it out yourself if you think that he did it. But I'm, as an expert, saying I can't say Kouri Richins did.
Maybe pause there for a minute.
Yeah.
So my understanding of Utah law is that lay jurors can, in fact, compare signatures in the absence of expert testimony. That is something they're allowed to do.
They can, but the problem is you're trying to layer on top of that this expert
Right.
who is giving an opinion that's a non-opinion to support a finding that the state wants, right?
Okay. Well,
And
maybe.
And it's not supported by the science. The second prong that we're
Pause
attacking.
with me for a minute, though.
Yeah.
I apologize.
No, it's fine.
So the concept of the state showing documents and arguing to the jury, take a look at these. You can see with your own eyes that doesn't look like Eric Richins' signature. That is permissible argument, and that is a permissible way to admit that evidence, correct?
I think they could try that. I mean, they could do that.
Right. Okay.
Right.
Then we look at, all right, does Mr. Throckmorton's analysis assist the finder of fact in determining whether the state has carried its burden of showing beyond a reasonable doubt that defendant forged some documents, right? And a step along that way from the state's perspective is, well, first we need to show that Eric didn't sign them.
Right.
So focus on that moment, that part for me for a moment. Why isn't Mr. Throckmorton's testimony admissible on that part?
Well, one big reason is that the initialing, there is no statement at all that Mr. Richins, so there's two documents at play. There's a power of attorney, which according to Mr. Burmester from the county, they're not even going to get into that unless we introduce the power of attorney as an exhibit. They're not even planning on doing it in their case in chief, which I just found out this morning.
Okay.
But let's say hypothetically, for some reason, we need the power of attorney. They're not even saying he didn't sign it. Like, their expert is not saying that's not his signature. They're only questioning whether he initialed each and every little blank on the side, right? Of which the expert cannot say. He cannot say he didn't. He cannot say to any degree of certainty whether Kouri did. He said absolutely no conclusion as to whether Kouri did, but he also can't say for
Well,
sure
hold
that
on.
Eric didn't.
Well, doesn't he say that there is a strong probability that Eric Richins did not author the ER initials on the power of attorney that defendant allegedly used? to
Why is
obtain a
she
fee
being
waiver?
so thick
Yes.
too?
Okay. He's used a strong probability for that, right?
Right, but that also provides for the possibility that Eric did initial it, right? I mean,
Certainly,
yeah.
and the jury can weigh
It's because they're desperately trying to keep Professor Throckmorton off the stand.
Well,
My
but
name is James Throckmorton, and I am an observer of people's signatures.
But I think the judge is making it clear in his tea leaves. I'm not going to let him get on the stand and say, I can't say it was, I can't say it wasn't Kouri. You know, like he's not going to let him do that, but he is going to let him render an opinion as to whether it was Eric. And it sounds like there is one that he might not let him do because his opinion was very weak.
Yeah, and I don't know if you heard it because you were handling your ICE situation, but
I was listening.
you know,
well.
he pointed out that lay jurors in Utah are allowed to eyeball a signature and come to their own conclusions as to whether or not something's been forged.
That's what they
So
call jurors, lay jurors.
that lay jurors,
Like,
yeah.
lay jurors. I thought he combined
Lagers, lagers,
like instead of jurors, like
lagers.
lay jurors. Okay, lay jurors. Right, got it.
Yeah, I can't get over Throckmorton's name. I'm sorry, just
It is
can't.
quite a name.
can weigh his testimony.
right.
In terms of admissibility, it would seem to be helpful to the trier of fact to receive an opinion from a qualified expert as to whether Eric Richins initialed a document or not, right? Because if he didn't, it leaves open the possibility that somebody else did. And then when we go to, well, does he have an opinion as to whether Kouri Richins was the one that initialed it?
Right.
I acknowledge that his level of certainty there is much lower, if not, there's no
Zero.
conclusive proof one way or the other.
Right.
But why wouldn't you want to let that in?
Right.
Right.
Well,
I
if
mean, if
he
the state wants to
testifies,
call him to say it, it certainly doesn't hurt defendant.
yeah, if he testifies at all, trust me, we do want that to come in.
Yeah.
The concern that I just have is just misleading this jury about these floating standards, because under the National Institutes of Science report, under the PCAST reports, you know, the reliability of subjective handwriting analysis has been brought into serious question by the general scientific community. I provided those materials in my brief.
Then put
And
on
to
the
have
evidence.
a layer of persuasion going to the jury of an expert that is relying on a science that has not been generally accepted by the national scientific community. And I specifically identified where in the NIST report and where in the PCAST report the scientific community says, look, this is just a subjective. It's no better than if me and you and the deputy all sat down and just guessed if it looked like it matched.
Doesn't Mr. Throckmorton reference studies saying that certified handwriting analysts are better than the lay public at identifying differences in simulated forgeries?
He does, and we would obviously attack that if he took a stand vigorously.
Sounds like you should
But
call
yes,
your own
he
expert.
does. He
about-
states that in his report, which, you know, may be enough to get you past the gatekeeping requirement. That's up to the court. I do also have some real concerns about whether portions of this needs to be redacted. One of the conclusions he was asked to, or he wasn't even asked, he did it sua sponte, I think only applies if it's a court, but he did it on his own when he was submitted the documents in question. One of the documents he was submitted on the amended report as recently as a few months ago. You know, now we're 3 years after the death, and he's just now being submitted new evidence, right, to evaluate. But that's what happened. And they gave him a report by the like a notary page where the notary had signed, and he just on his own makes a conclusion that a date has been altered. A number, not a letter, not handwriting. There's no evidence whatsoever that either that was asked of him to do, that he's qualified to do that there's any science backing that up.
I don't know that the state's offering that opinion at trial. Am I right about that, Mr. Rivers?
I don't even know what she's talking about.
Okay, so it sounds like a no.
Okay, well then if that report comes in, we're going to ask to redact that section
Reports
of it.
don't come in, they're hearsay.
Okay.
His demonstratives may come in.
Okay.
He usually has, he does in fact have demonstratives, and those will need to be disclosed to the defense, but the report's hearsay.
Right.
Sua sponte.
And also whether or not, I mean,
Of his own will.
that'll go to wait. We'll deal with that when he takes the stand. So I think really that it's really a two-based argument that we presented to the court. Two bases for our argument. One is that we don't believe it's helpful because there is no conclusion. Number two, we question the science of handwriting analysis. I provided the court with the scientific community's concern about the reliability of handwriting analysis, that it's really slowly but surely being relegated to junk science. And on that ground, we think, and what it adds is minuscule. It provides no guidance to the jury. So as far as we're concerned, if you're going to exercise a gatekeeping function at this point, this would be the point to do it. And we would ask that he be prohibited from testifying as an expert in this case.
Okay, you'll get the last word.
Yep.
He's
Mr.
letting him
Burke.
in, so don't waste too much
To
breath.
clarify, the state would offer Q1, Q2, Q4 in the event arguments come out in the defense case in chief. I don't know, we come up with 100 hypotheticals, but maybe something, she's a great businesswoman and somehow puts into question evidence that we might offer, which could include that power of attorney.
And Q1 and Q2 are
What's
definitely
happening with the
power of
waiving?
attorney. Is Q4 also?
Q4 is when Mr. Throckmorton is asked, all right, we have some knowns from Ms. Richins.
Right.
Now, do the same thing you did.
Okay.
So with regard to those would only,
Why are we
that is
waving
how
at
I
our
would see
screens?
us calling Mr. Throckmorton in rebuttal.
Throckmorton.
Good name.
Main point is there's not an agreement that they have to introduce the power of attorney before we would introduce it. It would be a whole set of facts that might make that come about.
Is the power of attorney, forgive me, I didn't go back and look, is the power of attorney the basis of one of the forgery charges?
It is not.
Okay. So why would the power of attorney be discussed?
Wait, your
Well,
wave
real
had to do with
quick-
a back scratcher?
Huh?
What was all the waving?
Huh? Oh, that was me using an old-fashioned back scratcher.
Oh, I missed the whole when someone mentioned anything about a back scratcher.
All right, this is a newlywed game question. What have I said repeatedly is the world's most perfect snack/treat? Think.
I mean, are you
Think.
talking about cereal flavored milk?
No. Something that actually exists, not something
Oh,
invented.
your favorite
I
snack?
not my favorite. I've said it's the most perfect, delicious treat of all time.
Oh Lord.
Come on, dude.
Is it a Rice Krispie treat?
Nailed it. That's why she's my girl. That's why she's my fucking girl.
Discussed in your case in chief at all?
I
Well,
just
I'm not offering the case in chief.
Okay,
That's
got it.
precisely.
Nailed
why.
it.
I see.
It would have to be some facts that arise in the defense case
Got it.
that would implicate offering that exhibit, and therefore its authenticity would
Okay.
be an issue.
Understood.
So that leaves us with just the true stage application signature, which is indeed at issue, identity of the forger and identity of that insurance fraud count.
So there, I understand the state's argument to be Mr. Throckmorton helps the trier of fact determine whether we've carried our burden on the forgery. count related to that insurance application because he says, he opines that it was probably not authored by Eric Richins and it appears to be a simulated forgery. Full
Correct.
stop.
Yes.
Okay. And that, in the state's view, is circumstantial evidence that makes it more likely that it was forged by Ms. Richins,
Yes.
given other factors related to motive, access, et cetera.
Yes.
Okay.
What the hell?
Yeah. I get this.
Will I what?
I was in the courtroom in Gersh v. Gersh, and so I know the court is familiar with
was supposed to say
Mr.
vouch.
Throckmorton, and
Yeah.
we've proffered all
Vouch.
those in our
Vouching.
pleadings, all his qualifications.
As long as
So
I've
I
known you.
don't intend to talk about that. However, there is a notion, and Mr. Throckmorton is here, President Court, we can call him as a witness.
True.
He would talk about how handwriting comparison has been used in courts for 200 years. And since the 70s, there's been an intense professionalization of that theory. And that history goes to prong C for demonstrating its threshold. I would also just like to address two other things, and that is the pathway forward, 2009.
The pathway. Why are we up on this again? He
where
ruled.
the scientific committee who's addressing all what is the status of every single forensic science, and there's a portion about handwriting, and the committee agrees that there may be some value in handwriting analysis.
Maybe some value.
The scientists who composed this document, of course, hold DNA at that time as being the gold standard. Obviously stated there were some things that need to be addressed, but certainly doesn't say it ought not be admitted. PCAST doesn't even directly address handwriting. It says all these other sciences like handwriting, these same things should be applied to them. But none of them say scientific community is rallying around some notion that it's junk science.
Certainly not in the state of Utah. I've looked. I cannot identify any time that Mr. Throckmorton has been excluded in the state of Utah. I can only find cases in which he's been admitted as an expert.
So
Unless
just
the court
shut up.
has
He's letting him in. Move
further
on.
questions.
I understand the state's position. Ms. Nestor.
Nothing else, Your Honor.
Okay.
Oh, I love when he rubs his hands.
He's the best.
Mrazek is great. He's a great
He's-
judge. He is such a good judge.
And these
Like,
lawyers
he
could make their jobs a hell of a lot easier if they just shut up.
can listen
and
to
let-
what he's saying.
Right.
He's very clear.
Yeah.
He's incredibly knowledgeable. He knows his shit.
It's to
He's
the point.
thought about everything that he's ruling on. He's clearly read the briefs. He's clearly read the law. He understands Utah law specifically. The guy is fucking great. He's going to be my favorite judge by the end of this Richins trial. I can guarantee you. He's on top of his shit. And we've seen some great judges, but he's next level. He's kind of like sitting there with an appellate court judge. Because I love the back and forth where he'll challenge a lawyer like we saw early on in the argument on the first motion. I love that. I love that word. Say like, because he's willing to listen. You know what I mean? It's like you get so many judges up there that just want to hear themselves fucking talk. It's their courtroom. They're ruling on it. You can fucking listen to what I'm saying. I don't really need to hear what the fuck you're saying. And when you do start talking, I'm barely listening. This ain't him. You know, like he's a really, really good judge. And I think that by the end of it, we will all be deeply, deeply in love with this judge. All right. So if you're late to the game, we have only gotten through one of the multitude of motions. The first motion was defense was seeking to bar a witness that was going to bring on some evidence regarding this theory called The Pathways to Violence.
For the most part, it was essentially granted for all intents and purposes.
I mean, it was and it wasn't.
I mean, if
they can't put her, their expert on and during their case in chief, they being the state.
no. The state can never put that expert on to say these are the characteristic traits of people who commit murder, and and as you can see, you've seen those characteristic traits in. They can only put this expert on only to say sometimes people murder people when there's no imminent threat or something like that. I mean, for all intensive purposes, their motion has been granted. It would take an extreme categorical, and I wish I starred, I forget who said it before, and they did it with capitalized categorical statement that no one murders anyone when there's not an imminent threat or something to that extent. And he said they can make case specific claims are fine. Like there was no imminent threat here. They can say that. There was no paramour. There was no rift in the marriage. There was no reason for her, who had so much to lose, to commit this murder. They just can't say no one ever murder someone when there's not a reason like X, Y, and Z. And then if they do that, the expert gets to come on, not to say what the characteristics are of people, but to say sometimes people murder when there is no imminent threat or whatever the case may be.
Or grievance. So the first step, the first marker on the pathway to violence is a grievance, followed by violent ideation, followed by research and planning.
And I think that's the point here, right? That the
So it
defense
starts
is going
out
to say
with
there's no
this
grievance,
motherfucker,
right?
and then it goes to, I just dreamed about killing this son of a bitch. And then it goes to, I'm going to have to Google how to murder this fucker. And then it goes to preparation. Now I've got to go to the depot and buy my tools.
But did
And
any of
then-
those things happen here? I don't even get it. Did any of those things happen here? What was the grievance? What was the Google search? What was the you'll give us the path on the break.
The pathways to violence. All right, let's go.
Before the court is the
Love when he rubs his
defendant's
hands like
motion to exclude the expert testimony of Matt Throckmorton. Mr. Throckmorton is offered to testify that the Eric Richins signature on the True Stage insurance application that is the subject of the charged forgery was probably not authored by Eric Richins and appears to be a simulated forgery written by someone who is familiar with or has access to Eric Richins' known signature. In addition, Mr. Throckmorton has been noticed as someone who may offer testimony in rebuttal or impeachment that there is a strong probability that Eric Richins did not author the ER initials on a power of attorney that the defendant allegedly used to obtain a HELOC on the Richins home, and that there are mere indications that the defendant wrote those initials. The court determines under Rule 702A that testimony, which would come in the state's case in chief and perhaps in rebuttal, respectively, is helpful to the trier of fact because it would assist the trier of fact in determining whether the state had met its burden to show that Ms. Richins committed the charged forgery count regarding the True Stage insurance application and may be relevant to show Ms. Richins' conduct related to the HELOC in rebuttal. Moreover, based upon the court's review of Mr. Throckmorton's CV, his education, training, experience, and his substantial history and experience in testifying, certainly in state courts in the state of Utah, the court finds that he is qualified as an expert in the field of handwriting analysis. Regarding defendant's objection to the reliability of Mr. Throckmorton's analysis, the court finds that his analysis and his methodology, and therefore his testimony, are sufficiently reliable under both rules 702 subsections B and C. Under C, the court finds that Mr. Throckmorton's analysis, because it is performed consistent with and measured against the SWIG-DOC standards, is generally accepted by the relevant handwriting analysis community. Moreover, even putting that aside, the court determines that his methods are reliable in as much as he is able to describe the way he compares the questioned documents to known samples of both Mr. Richins, the decedent, and also Ms. Richins, the defendant. He applies that reliable methodology to a sufficient set of known signatures, and he does so in a way that does not ignore any uncontroverted features of those signatures or other uncontroverted facts. That is, he applies his methodology to a sufficient set of facts or data in a reliable manner. Therefore, his testimony is admissible under Rule 702B. Finally, the court is not persuaded that his testimony, the probative value of which has been described, is substantially outweighed by the danger of unfair prejudice or other concerns under Rule 403. For these reasons, the defendant's motion to exclude Mr. Throckmorton in his entirety as an expert witness is respectfully denied. Mr. Burmester, do you need any clarification of the court's ruling?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
Okay. Next.
Ms. Benino.
Okay.
Is next week. Ms. Lester is also handling that one.
Very good.
Time
Hey.
is there.
You ready to
That's
turn
really
to
need
Dr.
iced
Benino,
coffee.
Ms. Nestor?
I might have to make move.
Ms. Shervanek, is this one yours?
Yes,
Yes.
Your
To
Honor.
Can
go
you
to
handle it?
A couple of
Starbucks?
questions?
Yes.
I was either going to do that or go to the Jewel and buy the bottle in Starbucks. Right. Or plus, I have to get coffee so I can make my own.
Ms. Shervanek, is there any admissible
And I don't get
evidence
coffee because you don't share
of
your.
domestic violence by defendant against Eric Richins prior
Good stop
to
at Starbucks for
the
you.
allegations related to
Just
February
pause it a sec,
14 of 2020?
Because this is important and I'm going to take over. So
I don't believe that would be.
YouTube. What are you on?
Law and crime trials. So as you can see, it's 1230 Mountain Standard right there.
Right. Where?
When you get to the stream, you'll see it. They have it above the logo. It says 12:30 p.m. Mountain Standard Time.
Okay. Oh, they're on a break. So maybe
they
I'm just
are?
going to wait. Yeah. See how
Oh.
long until they get on it.
Okay.
Against Eric Richins prior to the allegations.
Wait a while.
Ms. Shervanek, is there any admissible evidence of domestic violence by defendant against Eric Richins prior to the allegations related to February 14? of
Poison
2020?
sandwich.
I don't believe that would be presented in the state's case in chief.
Okay.
It's
Is
like,
there
I
any
think,
admissible
there's a
evidence that
while.
Eric Richins had any
Okay.
subjective knowledge
hey, stop
that
playing
defendant
this
attempted to
Oh.
poison him on February 14?
Jeez.
because it was, I thought it was important and I wanted to start with it on my end.
Okay.
Unless you're staying, it's a half hour, I think.
Oh, there's a
until
half. Yeah, no, I'm gonna go now because I'm
Maybe.
gonna take the guy on a walk during the break
Okay.
because it looks to be a nice day. Send me your order. I'll scoop yours what you want.
Okay.
Okay.
Yeah.
All right. I'll be back.
All right. Love you.
Love you.
to describe the way
All
he
right, let me rewind it.
compares he is able, moreover, even putting accepted by the, so it is performed consistent with and measured against the SWIG doc standards this community.
Okay.
Moreover,
sorry.
even putting that aside, in as much as questioned documents and also Ms. Richins, who, so in a way, signatures or other onset effects or data admissible on testimony, intuitively outweighed by. For these reasons, his entirety as an expert witness.
No, Your Honor.
Ms.
All right.
Nestor.
No, Your Honor.
Okay.
Okay, so it just got us back to when he finished with that last argument. Oh, sorry guys, my shoulders achy. And got us right to the start of the new issue because I wanted to hear all of that because the judge started with some good questions. So make sure we're all the way up.
Next.
Ms. Bonino.
Okay.
Is next, which Ms. Nestor is also handling that one.
Very good. You ready to turn to Dr. Benino, Ms. Nestor? Ms. Shervanek, is this one yours?
Yes, Your Honor.
May I ask you a couple of questions?
Yes.
Okay. Ms. Shervanek, is there any admissible evidence of domestic violence by defendant against Eric Richins prior to the allegations related to February 14 of 2022?
I don't believe that would be presented in the state's case in chief.
Okay. Is there any admissible evidence that Eric Richins had any subjective knowledge that defendant attempted to poison him on February 14, 2022?
That he had knowledge of it?
Right.
Yes.
Tell me what admissible evidence there is of that. We went through this for a couple of hours with Mr. Wright.
We did.
I spent some time on this yesterday. I don't know that there's any other admissible evidence that would show that Mr. Richins knew that anybody had attempted to hurt him.
Just
May
may
I
have a moment.
Of
Yeah,
course.
can we think about this? Because, oops. I mean, the judge is basically saying there's not. Try to convince me otherwise. Just try. Oh, this guy's going to chime in. He's like, oh, no, he's not. Just sit down. Yes, history and homicide. Thank you. I'll name and shame, or at least I'll see how many of you. 1,093 have liked the stream. Let's see. Well, I guess I can bloop bloop, guys, as we're. Wow, they're really taking some time to think about it.
I think the court is aware of what the admissible evidence is, the testimony from Josh Case and Cody Wright that the
Cody
admissible
Wright's not going to testify, as I understand it, trial, pursuant to, not at least regarding the events of February 14, 2022. I don't think he has any admissible testimony regarding that day.
He does.
But the
His
judge ruled
admissible
no.
Testimony are his observations, not the content of Eric Richins' conversation, but his observations about Eric Richins' demeanor.
You
How
didn't
his
see him.
voice
It
sounded.
was all on the phone.
Right, but his hearing observations about his voice, how he seemingly sounded on the phone during those conversations.
Nope.
And not the content that aren't admissible because of hearsay rules.
Nope.
But there are observations that he could make through that phone call that is admissible.
Maybe.
proffer that for me.
Yeah, let's
This is
flesh it out.
exactly what Mr. Wright testified to previously.
I don't know that he can give
Then
that
no.
testimony regarding his observation of the manner in which he was talking without saying what he was saying.
I disagree.
Well, the judge is the one that makes the decisions,
You're
lady.
proffering that Mr. Wright would say he sounded scared.
That he sounded somber, that he sounded concerned. I don't remember the exact words that he used when he testified, so I don't want to misstate those. But certainly he testified that during that phone call, Mr. Richins had a certain demeanor that struck him and that he remembered. And then he testified to what that demeanor was.
Okay. All right. Let's assume that comes in. Anything else?
There are also text messages between the defendant and Eric Richins about
Those have been
the sandwich
excluded.
that was left. And
So let's be specific. There's
Sure.
a text message from June between defendant and her friend indicating that she left a sandwich. And then there's a text message from Eric to Kouri at 11:33 a.m. on February 14th saying he's not feeling well. I'm going to go lay down. If I don't feel well, I'll go to the hospital. Anything else?
later in the day. Sorry, I don't have all of those messages at the forefront of my mind.
That's okay.
Your Honor, late in the day, late afternoon on February the 14th, there are text messages between the defendant and Eric Richins, which don't directly, he doesn't directly say something like, you just tried to poison me or something.
No.
But the state will argue that his messages and her non-responses for several hours, and then their ultimate exchange about he says something like, I got dinner for you and left it on the seat of your car or on the seat of my car. The state will argue that those indicate he was well aware of what happened on February 14th.
No, that
About 11 a.m.
indicates he didn't want to get
All
her
right.
sick. Maybe.
Okay.
Judge isn't buying that.
My concern is that
Y'all
in
fail.
the absence of admissible evidence, in the absence of the jury hearing the content of Mr. Richins' statements to Kouri Wright, there isn't a basis for the jury to conclude that Mr. Richins was acting inconsistently by staying with Ms. Richins or not doing something more acute between February 14 and the day he ultimately died. And without a reasonable basis to find that he acted inconsistently, I'm not sure why Dr. Venino's testimony is helpful to the trier of fact. And I'm more concerned that under 403, it would invite the jury to speculate about whether there was, in fact, a prior history or prior experiences of domestic violence that aren't in the record.
I think there are other instances, other facts that would be presented at our case in chief that are maybe not on their face what people typically consider domestic violence, meaning physical abuse. And that's the crux of it. For example, if there is infidelity, why do you stay in a relationship? For example,
But
if
does Dr.
someone is,
Venino have anything to say about that?
what's that?
Does Dr. Venino have anything to say about that?
I think these go to the counterintuitive behaviors. These go to manipulation and control that exist outside of physical abuse in these types of relationships, which is exactly what needs to be explained. Because the jurors may have questions of, why wouldn't you leave if you knew you were being cheated on? Why wouldn't you leave if you thought this person was taking your money?
Well, hold on. The jurors, lay jurors, are perfectly capable of figuring the first one out in their everyday experience. The second one as well. The state, I think, has a more thought-provoking point of, if you knew somebody tried to kill you, why'd you stay with them? Now that, I understand, would require, or may allow the admission of specialized knowledge regarding domestic violence relationships and cases. I got that. That's, I think, a valid argument. I'm just not sure there's any foundation for the jury to conclude that this relationship involved domestic violence before Mr. Richins ultimately died.
I think that the court is considering this as domestic violence in the context of a typical physical abuse case.
No, he's
that
not.
We're not alleging.
I'm not suggesting otherwise. I'm more concerned with Dr. Venino talking about it that way.
And she would not.
Then what does she do that's helpful?
It's in her proffer. She can certainly testify to it, but it is the counterintuitive behaviors, it's power and control and manipulation outside of physical abuse that does not include physical abuse.
Okay.
He's ruling against you.
Mr. Bloodworth, did you want to add anything?
Yes, Your Honor, thank you. As it relates to what I would most likely expect the testimony to involve Valentine's Day, why not? Why if you thought she just murdered you, do you still stay?
Right.
And it seems to me that where the court might be hung up is in
Establishing.
probative value of the evidence showing that he knew.
Right.
Versus
Or lack thereof,
Or
or
lack
just
thereof.
lack of evidence showing that he knew.
the
Yeah.
probative evidence.
No,
showing
no
that he
evidence.
knew.
That's what you guys.
Versus the prejudice that would come along with perhaps an improper inference.
An improper inference of something prior to February 14th.
Prior to
That's
February
that.
14th,
Right.
correct, Your Honor. So I don't know that at this point in time, the court has the full amount of evidence that Eric knew, despite kind of some proffers just now. This may be a decision that the court wants to reserve on under the scope, kind of make the reservation of the court needs to hear the evidence that Eric knew. Upon hearing the evidence that Eric knew,
What are you trying to hide it?
the court can make a 403 decision. I think the court can make probably the 702 decision part of that today, but I think the court needs more information on the probative value of the evidence that Eric knew.
The judge is telling you he sees
Pause
no
there for a
evidence.
Yes, sir.
Ms. Nesser.
Your Honor, Ms. Dr. Venino, I think she's a doctor. She has certainly not been identified as a family relations expert, a good or bad marriage expert, a marriage counselor.
I know, but respond to what Mr. Bloodworth just said.
That's what I'm trying to get
No,
to.
but
So if they're
Gosh.
trying to argue,
none of them are listening to this judge. He's saying, respond to what he just said. Her first answer should be, Your Honor, the state keeps ignoring the fact that there is no admissible evidence that he knew. Without any foundation to establish that he knew, based on all of the evidence that we both know of right now, and unless the state is offering something new, I would say you grant our motion and it is subject to review should the state present new evidence that as of this date, no one here knows about. Blah, blah, blah.
that's what I'm trying to get to. So if they're trying to argue that there's been infidelity or there's been arguments in their marriage, infidelity on both sides of their marriage, which is an answer to a question about why you wouldn't leave. But that goes way beyond what the narrow area that she's qualified in. She's qualified in domestic violence. If you look at her CV, 99% of it deals with sexual assault victims. A tiny percent of it deals with domestic violence in the home that is not connected to sexual assault. Almost all of it's connected to sexual assault. So her specialty, while they may want to put that case on that, that she was a bad wife or whatever they want to try to argue, this expert is being called to opine about violence in the home, not just being a bad wife or being, controlling or manipulative of your spouse, but of a spouse being in fear due to emotional or physical coercion to the point of being in fear. And there's zero evidence that I've seen in 10 terabytes. What are we up to? 12 terabytes? 12 terabytes of discovery. And if they've got some evidence out there that there was domestic violence in this relationship and I don't have it yet, I submit it's not coming in. So the prejudice would be outrageous to allow this witness to get on the stand and opine expertly that because there were problems in the marriage, that this was a situation that put Eric Richins in fear of domestic violence.
That's not what Mr. Bloodworth was arguing. He was arguing that I should wait to see how the evidence comes in the state's case in chief to determine whether they've laid a foundation for the jury to draw a reasonable inference that Eric Richins did in fact conclude subjectively that Kouri Richins tried to kill him on February 14th and then stayed with her. If they do, I think their argument that Dr. Venino's testimony is helpful to the trier of fact is stronger. And we can have a conversation about it today or tomorrow or in the future. If they don't lay the foundation, I don't think it can come in because it won't be helpful to the trier of fact. And even if it had some minimal helpfulness, it's the danger of inviting the jury to speculate about whether there was some other history prior to February 14 regarding domestic violence, whether they've misheard the evidence and are confused or misled. That's too high under 403. But Mr. Bloodworth's point on behalf of the state is, rather than doing this by proffer, why don't you just hear it come in and then decide if we can call Dr. Venino after we've
answer that.
Tried to lay the foundation for what we think we're going to be able to show.
Well, one of the problems is, if she's going to come in, there's things we as lawyers need to do to prepare for that. One thing, we may want to get a rebuttal witness. We honestly did not believe that her testimony would ever come in at this trial because there's zero evidence of domestic violence on Kouri's part, right? So there are things we need to do to prepare that preparing at the last minute puts us at a significant disadvantage. I think you're always entitled to revisit any ruling you ever make, right? You're the judge. You can revisit a ruling at any point in a trial if the evidence changes or something changes.
Certainly.
But as this evidence stands right now, they have not propounded evidence sufficient to get her testimony in at this point. If they do that later, then they can ask you to reconsider. But right now, I think the only proper ruling would be to rule that there's no standing right now to let her testify. If that changes, you can reconsider it. But right now, they've not propounded that evidence. I've never seen that evidence. And we're, a month out from trial. I seriously doubt we're ever going to see it. But that's what we would ask you to do at this point.
You acknowledge there's a little bit of internal inconsistency to what you just said. I agree with the last part that I can say, well, she can't testify until you lay foundation.
Right.
But once I say they've laid foundation, you're going to be right on the horns of the same dilemma you just described in terms of needing to have a rebuttal expert prepared.
I would compel them, tell them to announce it now, period. Proffer it now if it exists.
How we approach that, right?
Talk to me about, assume that there was foundation in the record today, that there was admissible evidence that Eric Richins had a subjective belief, well-founded or otherwise, that Ms. Richins attempted to poison him on February 14, 2022, and elected not to do anything about it. It would seem that that would satisfy the 702A standard for helpfulness for the jury in terms of explaining why people who suffer violence in a domestic relationship don't immediately get out of it.
That still doesn't mean that there's any evidence of that violence in the relationship. Even if
you got to accept my hypothetical.
Right.
That he subjectively believed that she did and didn't get out. That would seem to open the door to Dr. Venino's testimony as helpful to the trier of fact. Do you disagree?
I would disagree with that.
Tell me why.
obviously.
There you go.
Well, based on her area of expertise, as I read her proffer, her theory is, it's almost like we use the word grooming in child sexual assault material cases, but that idea of being in such a violent and traumatic relationship that basically a person just gives up. It's kind of the
Well,
burning
that's
bed.
not what she says. I mean, quote, there are many reasons that a victim of intimate partner abuse doesn't simply leave an abusive relationship, including love/hope for change, economic constraints, lack of perceived acceptable alternatives, social isolation, and fear.
Right. There's no evidence of any of that.
Well-
No, but in my hypothetical, there would be evidence that he believed that was the case.
Okay. Accepting that hypothetical, that evidence that does not exist now.
Oh my gosh, there's something wrong with her. He's not saying a history of domestic violence over and above this one prior attempt at murdering him with his sandwich. The judge is telling her if they were able to lay the foundation with admissible evidence that I'm telling them, even though they just keep pretending they can admit it, is not going to be admitted, that he knew, suspected, was pretty damn sure she tried to kill him with that sandwich, why he stayed. And this lawyer seems to just be going back to there's not like this long history here of controlling behavior, of abuse. And the judge just confronted that or just addressed that by saying she also says love, money, that there are these other reasons that have literally nothing to do with fear or, control. Uh, and now she just keeps saying there's no evidence of it. Well, there is evidence of it. Like we know he knew, but there is no admissible evidence of it. And I still think she's missing the point, but let's see.
Somehow accepting that hypothetical, that evidence that does not exist now somehow appears at trial for the first time ever.
Right.
And is allowed in, even though we object like crazy because they didn't give it to us before. The argument would be that her testimony, my understanding is she's a blind expert, right?
Right.
So she's not going to be able to take that evidence and analyze it anyway. So how does it change her position at all from right now?
Well, because right now, in the absence of the foundation that you assert is missing, that I have concerns is missing, that Mr. Bloodworth is saying, hold the phone, let us lay it at trial. I agree that her testimony would be unhelpful because it's not relevant to
Right.
the facts of the case.
Right.
If they lay the foundation, it suddenly becomes relevant to the facts of the case.
Another argument she should be making is that the unfairness and the resources and the judicial economy, that if the prosecution cannot tell, this is not trial by ambush, Your Honor. If they have some way that they intend to use the evidence that they're just not, that they don't want to disclose right now, or they're just hoping they're going to figure out, a way to use the evidence in a way, it leaves us at a disadvantage at getting an expert. Because he said, how does that address your concern that you won't have an expert? I don't know. Do you guys know, are these court appointed lawyers or hired lawyers? They've got to talk about a lot. If it's hired lawyers, they have to talk about allotting of resources. This is not someone, no one is independently, wealthy that they can afford every expert that they might need. And again, this is not trial by ambush. And if the state can't tell you this stuff today or tomorrow or whatever day soon, let them think about it, then they should be barred outright. They either can proffer the evidence and it exists in the world today, right now, or they they can't and it's excluded. Now, if the state's trying to say, well, when we introduce this evidence that the judge is saying, some of which the judge is saying you're not going to be able to introduce, which they seem to not be grasping, but when we, put all these pieces together, that he made a sandwich and said, I'm leaving it on your seat, whatever the case may be. And all of that is enough to infer that he knew she tried to kill him. now I forget where I was going or what I was saying. Oh, that they think that at trial they're going to be able to put it together so much more in a much more compelling manner that it's going to cause the judge to change his mind. The evidence is the evidence, So push that here. Push the economical difficulties, the you know the trial efficiency, and the fact that this isn't an ambush situation. Like, just say what you got right now so that we cannot be surprised by what it is we have to combat.
I don't know. I think it gets very, very painfully close to opining on the mental state. I mean, it's the same argument that you raised before when you were talking about the testimony of the profiler, right? Like, how close are you going to walk to that line that you're giving an expert opinion about what's inside someone's brain and then extrapolating that, one step over to defense counsel table, right? And I mean, basically her testimony would be under circumstances where someone believes that their life is in danger, it's perfectly rational for them to stay. So it must show that they did believe it, but that they just didn't act on it. I mean, she's opining on what would be in Eric Richins.
I mean, they'd offer her testimony for the inverse.
Right.
The fact that he didn't leave is not necessarily an indication that an attempt in his life didn't happen on February 14th.
I mean, I had a case very similar to this one time. I had a rape case where the victim of the alleged rape testified wholly inconsistently, like 6 different times about what happened to her, to the extent of like where it happened, how often it happened, in what position it happened. Everything was just absolutely in every statement she gave. And the federal government called a witness to testify, an expert, to testify that rape victims are more likely to be confused. So the fact that her statements are inconsistent are consistent with trauma and make it more likely that she was a rape victim, right? And we have this huge battle over that, about how far can you use an expert to explain away your inconsistent evidence, right? Evidence that's inconsistent with guilt. And it shouldn't be that you should be able to call an expert witness and say, hey, we're presenting something that's wholly illogical and irrational, but we're going to call this expert up here and say, well, this certainly would be a perfectly honest reason why Mr. Richins would believe that, it was a healthy thing to stay with someone who just tried to murder him, right? And so it eliminates their problem with their evidence, and it goes into his state of mind, which an expert shouldn't be called to testify about.
You missed the point again.
Well, we could talk about that under Diaz.
Right.
But, okay, I understand your position. Yeah. Ms. Shermack, Mr. Bloodworth, anything else today?
No, sir.
Okay. Let me take it. Oh, I'm sorry.
Sorry, Your Honor.
That's okay. Anything else on the record at the moment?
No, sir.
Let me take a 10-minute break. Okay, thank you.
Well, so it's only 10 minutes, so we've got. I hope he comes back and makes some of these points on his own, guys. So.
All right. The issue before the court is the defendant's motion to exclude Dr. Sherry Venino, who is an expert noticed by the state or disclosed by the state to give testimony about domestic violence relationships, to include characteristics, dynamics, patterns, and victim trauma.
That's a little.
Dr. Venino is disclosed as a blind expert who is being offered to testify regarding a set of principles regarding domestic violence relationships without having either viewed or opining on any case-specific evidence. The state asserts that characteristics of domestic violence victims are relevant because when applied to the facts of this case, they will help a jury understand, for example, why Eric Richins continued to live with the defendant after she allegedly administered fentanyl to him on February 14, 2022. Currently, the court has not seen in the record a non-speculative basis for the jury to draw an inference that Eric Richins had any subjective knowledge of Ms. Richins' alleged attempt to poison him on February 14, 2022. And in the absence of a non-speculative basis for the jury to draw that inference, that is, that Eric knew that his wife had attempted to hurt him, there's no relevance to Dr. Venino's testimony regarding the dynamics of domestic violence relationships, because there would be no foundation for the jury to conclude that the relationship between Kouri Richins and Eric Richins qualifies as a domestic violence relationship. In the absence of that foundation, Dr. Venino's testimony would not be helpful to the trier of fact under Rule 702A, and given its lack of probative value, it would be inadmissible under Rule 403, not only as not being relevant under 401 and 402, but also under Rule 403 as inviting the jury to speculate about whether there was some other evidence of a domestic violence relationship between these two that wasn't in evidence in the court. It might confuse the jury regarding the testimony that is admissible. It might mislead them regarding the reasonable inferences to be drawn from it. So sitting here today, there isn't a basis to allow Dr. Venino to testify. However, the state makes a reasonable point that the court hasn't seen all the evidence, isn't aware of all the evidence, hasn't seen how it would come in, and the state may yet be able to lay the missing foundation during its case in chief. And so while the court determines that sitting here today, there is not a basis to allow Dr. Venino to testify, the court acknowledges that that basis may arise through the state's case in chief, if the state in its case in chief lays a sufficient foundation for the jury to draw a non-speculative inference that Eric Richins was aware that defendant tried to hurt him on February 14, 2022, the court will revisit defendant's argument that Dr. Venino's testimony should nonetheless be excluded under Rule 403, given the entire context of the evidentiary record at that point. In so ruling, the court also rules that Dr. Venino is qualified to offer this type of testimony under Rule 702A, and that her testimony, if it becomes helpful to the trier of fact, and if it survives a 403 balancing test, satisfies the minimum threshold for reliability under Rule 702B. Ms. Shervanek, Mr. Bloodworth, do you need any clarification of the court?
So what he just said is a lot of things. So he shifted his terminology from admissible evidence to a non-speculative basis, because everything that the state tried to lay out is speculation. He sounded somber. He left a sandwich on her chair. So he shifted his terminology to a non-speculative basis, which seems unlikely that it's going to come to fruition. He also talked about 403, the 403 Balancing Act. Once you get, over all of that, is it still prejudicial? Could it confuse the jury? And lastly, he said, if all of these other things are met, you lay that foundation, non-speculative foundation, and we get over the balancing test. I'm saying under 704B that she has met the threshold requirement that the testimony this expert wants to offer is scientific, it's reliable, it's been properly applied to the facts of this case, and she's going to be allowed to testify as an expert both under 404A and 404B. So now he's getting to his typical, do you have any questions? And this is where I would chime in again and say, Your Honor, I appreciate and understand and respect your ruling. I would just like to voice my concern about my ability to prepare for trial, and my concern about, why the state isn't doing this now. Can we set this for another day, which the state has to make that proffer? If the evidence exists and this isn't trial by ambush, let's make them make it so that I can have my expert lined up and we can know for sure whether this is coming in. And who knows how he would respond to that, but I'd be trying it here if I had forgotten it as she has thus far. So
No, Your Honor, that's sufficient. Thank you.
Ms. Nestor.
No, Your Honor.
Okay.
there you go.
All
Says
right.
no.
Any other expert witness issues we need to handle today? Ms. Lewis.
Not today, Your Honor, no.
Okay. Mr. Burmester.
No, nothing.
Ms. Shervanek.
No, Your Honor.
All right.
All right, we're done.
Okay.
Oh,
Sitting here at this moment, I'm not prepared to get too deep into the other motions in limine. May we take those up tomorrow? Any practical considerations that we need to think about, or are we just going to handle those one at a time tomorrow?
what about the
based on-
practical one I forgot already?
Those are mostly going to be mine, Your Honor. Some of them are Ms. Lewis's. Alex has, I think, one or two. Mr. Ramos, sorry. The only question we had, and I'm just not sure. So these motions were filed privately because they deal with evidence that we're asking not be admissible
Right.
at trial.
So she means under
I didn't know
seal
if the court intended to have the hearing
publicly.
public or not public, because once it's aired, it defeats the purpose of why it was all filed privately.
I mean, there is some space between the way we talk about stuff and the documents. For example, there are certain documents or transcripts in which the state is seeking to admit a portion, but not the whole thing. And it's sometimes because the part they're not seeking to admit would be unfairly prejudicial, not relevant, inflammatory.
Right.
Nonetheless, your point is well taken. Do you have a request?
Obviously it would be our preference that it all be private and then maybe your ruling could be public.
Sure.
Because your ruling can craft it in such a way that you don't reveal inadmissible evidence. But it seems to me that the danger that a bunch of inadmissible evidence is going to be broadcast to all of our jury who now have received jury questionnaires and know they're on deck.
Right.
Could be problematic. So we would ask that the hearing be sealed and then maybe just the ruling be made public.
Okay. What's the state's position?
No objection to that, Your Honor.
All right.
Let me think about it.
Tomorrow, January 8th, the court has set a hearing to hear oral argument on numerous motions in limine filed by the state and by defendant related to a number of pieces of testimony, documents, audio recordings, video recordings, other pieces of evidence. The admissibility of those things is as yet undetermined. And the court is persuaded by counsel's stipulation that to ensure the integrity of voir dire and the jury pool, and in recognition of the fact that potential jurors have already filled out their questionnaires, and so there would be a reduced ability tomorrow, the day after, to investigate whether they're exposed to information regarding inadmissible evidence. The court finds that it is necessary to close tomorrow's hearing to the public and to seal the audio recording of it so that it is available only to counsel, but not to the public at large. The court's ruling regarding what is admissible and what is not will be part of the public record.
It's fair,
Any
guys.
clarification on that, Ms. Nestor?
No, Your Honor.
Mr. Bloodworth?
No, Your Honor.
All right. Folks, we're likely to get some weather tonight, tomorrow morning. Is 9:30 an appropriate time? Do you need a little more travel time?
10.
That's fine. 10 a.m., Mr. Bloodworth,
Yes, Your Honor, that works. I have one other
please.
I did
issue.
too, but go ahead. Oh, I just had a question. I don't know if you're prepared to answer this, but we do have a number of motions tomorrow, and in terms of expediency, it would be helpful if you have specific things you'd like us to be prepared to address. Maybe if we knew some of that in advance, if there's particular case law you want to discuss.
No, I'm going to be going off. I mean, I do have lots of practical questions about, all right, who's offering this? How's it coming in? Right? Is this case in chief? Is this in repeat? I need to understand the order of events. But I will go off the papers. And I'm happy to follow your lead in terms of the order in which you want to do things. So talk to each other. If you want to do Mr. Ramos's first so he can go do something, that's fine. Will you just tell me how you want to?
He doesn't get to leave.
Okay. Anything else, Ms. Lewis?
No, Your Honor.
Mr. Bloodworth?
Your Honor, clarification on the ceiling.
Yeah.
The victim and defendant's family are permitted in the courtroom.
Certainly victim representative.
Just one.
Just one.
Okay.
Yeah. Would be similar to what we would do for jury selection, for example. So during individual voir dire, victim representative is allowed to be present. I don't even know if Ms. Richins wants a family member present.
I'm
So-
sorry.
No, out of abundance of caution, because they've received subpoenas, it's
Right.
probably better they not.
Okay. So if you would pick a representative for the Richins family,
I think there's two that are designated.
that's fine. I understand.
Your Honor, one more thing. The state in some of its motions have styled them as motion to pre-admit.
Right.
The defense in some objections have said the state lacks, or the court lacks authority to pre-admit. I don't fully know what the answer is, but
Well, no, I certainly have the authority to say that, for example, defendant has admitted that she wrote a certain letter, so 901 is satisfied.
sure that. But as far as the relief the state is requesting, if the state has styled it as a motion to pre-admit, the state would like to amend any of those stylings to a motion to determine admissibility.
Understood.
Thank you.
Okay. Some of my questions will be, is there a genuine issue regarding the the authenticity
Sure.
of this document? Who's your witness that's going to bring it in? Something like that.
Yes.
Okay.
No, we're nothing further.
Okay. Ms. Nestor, Ms. Lewis, Mr. Ramos, I'm not suggesting that the defendant should do anything other than put the state to its burden of proof and require them to lay a foundation for stuff they want to admit. However, I do want you to be at least a little bit thoughtful on both sides of the V here about the juror's time and the court's time. And so if there are indisputably authentic documents that you can stipulate regarding authenticity and foundation, but you want to reserve and then discuss your arguments regarding admissibility,
Right.
let me know which one those
Your
are.
Honor, I actually have been spending a great deal of time on that. I've come up with lots and lots.
So I'm just going to pause right there. So what the judge is asking them to do is to stipulate to the foundation, to the authenticity of certain documents, but not necessarily the admissibility. I've actually tried to do that. It was actually in a federal case, and I kept saying, Your Honor, I don't object to the foundation, but I might have evidentiary, objections to the admissibility. I'm not objecting to the authenticity of this document. And then the judge is like, so you're withdrawing any objection to this piece of evidence whatsoever. I'm like, absolutely not. That's not what I'm saying or doing. So what this judge is doing here is very much appreciated. He's saying, look, I'm going to let you not make them bring in, the X, Y, and Z just to establish that a document is what it purports to be, that a video is the video from, wherever. Like you get the cop that comes in and says, yeah, I operate the Sallyport camera and this was from our Sally port, and here's how our camera works. And, obviously in using this Sally port example is bad because how it operates was very much important. But you see what I'm saying? But still allow the defense to make any objection to its admissibility otherwise, so it's not relevant, it's prejudicial, it's, it's not clear enough, it's speculative, whatever the case may be. So, he's a damn good judge. He's a damn good judge.
I actually have been spending a great deal of time on that. I've come up with lots and lots that we're willing to stipulate to authenticity. I told the prosecution I would get that to them, I think Monday, but something came up in my family and I wasn't able to do that. But I will try to get that to them by Friday.
Okay.
But there's quite a few documents that we're not going to have a problem with authenticity, and we're not going to ask them to bring in sponsoring witnesses or like jail calls and bank records and pictures and all that kind of stuff. And I'm doing it one by one by one, and will have a comprehensive list by Friday, hopefully.
Thank you.
Thank you.
Okay. Mr. Bloodworth, anything else today? Ms. Lewis. All right. We'll reconvene 10 a.m. tomorrow morning. 2 victim representatives are welcome to attend. The rest of the public will be excluded.
Damn.
Please travel safely. Nice to see
All the
you.
motions in limine, they're shutting them down, huh?
Well, just the motions about admissibility of evidence. So yeah,
That's
I don't know what else they have.
I mean, that's everything. Like in terms of everything that's left.
Yeah.
I mean, I get it, especially since the jury notices have gone out. I mean,
Yeah, so I put
it's the prudent
somebody,
move. It's the prudent
somebody
move.
Dragonfly said, bullshit. Do not be hiding stuff. Grr. And like Bob just said, with jury, the closer you get to trial, the more this is an issue. When you're talking years. Whoa.
Wow.
Sorry, guys.
Basketball.
Wow. Sorry, guys. I just probably blew so many people's eardrums.
Maybe.
I blew my own. It was like insane.
The whistle didn't help.
So the closer you get to trial, and especially like Bob just said, and the court noted and the defense noted, there's jurors already have their questionnaires. So you can't even like re-question them in advance so that you're phasing, the people out before you get to your jury pool. And that this is evidence that might never be admitted. It would be very prejudicial. So I don't consider this hiding stuff. I'm not looking at this in that way. This is, it's necessary. It's sort of different. So
Yeah, no, we're all about sunlight, but this is a different situation. Because depending on the area that you're in, obviously Utah is not overly populated. This is probably pretty high on the list in terms of media coverage of cases that are currently going on in that area. And if they were to have these motions in limine where there's certain things that are not necessarily going to be admissible at trial, but that could be damning, you don't want potential jurors seeing it on the news and then sitting down at trial having seen this evidence that was kept out but now is stuck in their brain, and they know it exists because that bullshit, the Jedi mind thing, everything that you walked in here thinking, I want you to somehow magically push it into the corner of your mind and in no way ever access, like that shit doesn't work. It's bullshit.
Right.
It's like, I hate when judges try to pull that when they're trying to get a juror that has
A yes
clearly
man.
been, it's like, but once you've got them for cause and then they rehabilitate them with that bullshit, I'm like, man, no.
Right. Where they're giving you no option but to say, yes, Your Honor, I can do what you just
It's
said,
like the Hobbs
even though I just told you I'm biased,
Yeah.
But and the other thing is, like, think about it this way. Even if they're not watching trial coverage, but something big gets discussed, which clearly it's enough that they were allowed to file it under seal. Now you've got the news talking about it, especially the local news, not to mention the national news. So you would be getting all the opinions of, everybody else on evidence that even evidence that might ultimately
Like me
come
on
in.
Court TV with Vinny.
Right.
So Bob, the the walk the dog letter that's not coming in. Do you think that, that kind of shit? And it's just not we want a fair trial. We want a fair trial. And this is the best way to ensure it. Look, this judge doesn't do anything without thinking diligently about it. That's for sure. All right. So before we dip, I figure we might as well do this.
Well,
Tracy,
show your thing too.
what thing?
Your pathways to violence. I want to see it.
Oh yeah. Okay.
Sorry. And then I also want to ask you what you thought about if the defense would have kind of come back to this judge with, hey, let's talk about, we need this expert. How about we give them time to craft their most strongest offer of proof? Because this isn't supposed to be hide the ball, ambush, surprise. Do you think he might have changed his opinion and said, all right, yeah, I appreciate all those points are well taken. We're coming back tomorrow. Can you be prepared tomorrow to present me with whatever admissible, non-speculative evidence you think establishes that, is going to be sufficient to establish that he knew that she tried to kill him with the sandwich?
Were you talking to me?
I most certainly was.
Well, I was trying to set shit up. I was trying to, there's something, I didn't hear a word you were saying. I was working. Like
Oh.
come on, you knew I was trying to pull shit up. So what were your, I listened to your exquisite legal analysis regarding Bonito or Venito, whatever.
Right. So you
that
think,
expert-
basically, I just said, do you think if she would have circled back to it and told the judge, hey, have them come back next week, tomorrow, so I can get an expert, that he would have been like, point well taken?
Yes. You're the smartest lawyer on LawTube. You are, but like your analysis is spot on, because when the defense brought up the fact, like, well, what is this evidence that we don't know about? We're like on the eve of trial here. What is this? I mean, that's problematic in a lot of different ways. I mean, even with an offer of proof, I mean, are they saying that they have the evidence, that the defense has the evidence, and they're just not looking at it the right way?
It
Like,
seems to me
clearly-
that they are.
Yeah, I mean, what?
Or that they just think that they're going to be able to offer it in such a more compelling manner at trial.
I mean,
That the
I
judge-
thought the judge's ruling was fair in light of, I mean, he was very clear that as it stands right now, that expert's not coming in.
I have to tell you the truth. My fear here.
Yes.
I don't think that the defense is picking up on all of the cues of what the judge is saying, such that they're going to make sufficient objections at trial. I think if you read even between the lines, but he says it like you and I, when she the prosecutor stood back up and said, yes, Your Honor, I think this expert, the pathways to whatever expert, should be able
Violence,
to.
there it is, right there for you. That's the
Right.
pathway to violence. Right
I
there.
pointed with my bad arm, so not high enough, but that
Ooh.
I think this pathways to violence expert should be able to get on the stand, give the jury all the traits and characteristics of people who engage in targeted violence, and then they should be able to use that to compare to the traits and characteristics. And you and I are going, nope. Like, we're both like, the judge literally just said that's the exact thing you cannot do.
Right.
I just don't know, like, does the defense understand? Also, do they understand how far they can step before they hit that categorical? I mean, he kept saying categorical.
I think these two, so Kouri Richins' original attorney was a woman named Sky Lazaro. I know her. I happened to reach out. We were on Court TV together, and it was right after she dipped out of this case, and there was this whole bizarre circumstance where Kouri Richins was basically saying that Sky Lazaro cooked up the whole fucking walk the dog letter. Like, it was this crazy shit. So she ends up, their whole firm withdrew. Like, Sky Lazaro's entire firm was handling this. She's a highly competent attorney.
When you say
handled
cooked up, like, made her write it? Like,
Yeah.
or do you not
Well,
know
I mean,
exactly what?
she basically said that, like that she was following the advice of her lawyer, and then she switched over, like I was writing a book. This is like, so Sky ended up dipping. I think that they are, and maybe Chad can correct me if I'm wrong. I think they are court appointed. I think they're public defenders.
Right.
So
So
you're,
for that
and,
reason,
and that's no slight to kind of say, oh, well, I agree with your point in terms of being a little concerned, because it seems like these attorneys were not really grasping who appears to be a very clear judge in terms of the way he deliberately speaks and lays things out and gives the attorneys an opportunity again to respond. And he will he'll inquire from them, wanting some kind of response when he has pushback on a particular issue. And I did get this, I got the same sense, like shit was either going over their heads or right through. I don't
right,
know
or they were
which one
just
it
so
was.
focused on the point they wanted to make that they, that they were ignoring, what he, like a gift he's giving them in a sense. Like, this is my mindset. Grab onto it and expound on it.
Yeah. I mean, to me, if you were to scorecard this, it was a winning day for the defense. I mean, they
Huge.
essentially, they won a majority of the motions, the handwriting thing. I think jurors are going to take that for what it's worth, because when you get into the nuts and bolts of a handwriting expert, and it gets pretty dry.
Can I ask you, and I'm not trying to put you on the spot, so I'm going to ask Chat, actually. Chat, do you guys know, because I don't recall, was there a motion to sever the financial crime, whatever these charges that deal with was it fraud or forgery or whatever from the murder charges?
I'm going to answer in the affirmative, but I'm double checking with our friend of the show.
Okay, because maybe he decided that it was, um, you know, intrinsic, which might be what they were talking about earlier as well, intrinsic to the murder offense somehow. Well, all good names says yes. Tracy says I believe so. Living, and you said that that's Kraken. Living said yes.
Yeah.
And well, I can't see. Alina Lee says I think they've been severed. So I don't know.
Yeah, if they were severed, that, like, I remember there being a motion to sever the financial crimes from the murder.
Okay. So let's look at
All right. So this is the pathway to violence as cooked up by three guys sitting in a room watching cats.
So far with that, just seeing the first three, to me, there's nothing helpful about the actual pathways, which is what I think the judge was saying when he said it's just like some people commit murder when they, don't have a.
I mean, this is fucking ridiculous. The first thing right here, grievance, often demonstrated through hostile, sarcastic, or bitter speech and writings, or by stares and so their grievance can start at something as minimal as that.
Well, what's the grievance here?
I don't know. Like, it seems like Festivus really would put an end to the path to violence if we just instituted it as a national holiday.
Yes.
Airing a grievance.
Can you reach out to the FBI, the BAU unit, be like, look,
I'm going to go higher.
Festivus.
I'm going to go to the legislator. I'm going to say, look,
take these pathways of violence.
I'm aware of the pathways to violence, and look, there's an easy solution here. We just need to write up a law enacting that Festivus for the rest of us becomes the national holiday that we all celebrate. I mean, it starts with airing of grievances. That right there, it stops it dead at the first marker. Grievance done.
Aired.
We've aired them over.
Right,
no
or
more
there could
violence.
be the purge.
We've solved all the violence. Oh, history. I love the Fight Club reference there. I love the Fight Club reference. Okay, so that's the first marker is grievance. It starts with that motherfucker. Like, so basically everybody on Twitter is at the first marker of the pathway to violence.
We're all on the first pathway. Everybody
Well,
has a grievance.
especially the people on Twitter.
Jesus.
Who's that?
Cameron, and it like shocked my shoulder.
Yeah, she's floating around like all
Came out
wide
of the
awake
darkness.
now. She slept till 2 in the afternoon after staying up all night. She's on one. Like this whole well, I'd die to be a fly on the wall for this. Allie's looking for something. Allie's like, I don't know. Okay. All right. So marker 2. It goes from the grievance. So somebody talking shit on Twitter, calling you a fucking moron, saying you're a fucking idiot, that you fuck cats or whatever they're saying. And then it goes to violent ideation. Okay. So the grievance spawns thoughts or fantasies of murder and violence. So this person that's just relentlessly fucking with you on Twitter, you now find yourself dreaming, maybe even daydreaming of murdering this faceless person behind a keyboard because of their constant berating of you. It then moves to marker 3, which is research and planning. So you're like, all right, look, I got to find out who this motherfucker is. So I'm going to start digging. So you start digging into the keyboard warrior that has been torturing you for months. You're trying to figure out who it is. You're trying to figure out, okay, if I find out
am I
who this
gonna
person
do it?
is, how am I going to do it? Where do they live? What's the best way that I'm not going to get caught? You figure that out. You then move to marker number 4, which is preparation. And that is where you go get training. You go to your local Tai Chi place and teach them that you ask them to teach you the ways of Tai Chi so that your hands become lethal weapons, or you purchase weapons and other materials. And your friends are forewarned. You say, hey, look, man, if I'm not around, like after next week for say 30 years, don't be worried. It's fine. It's fine. Don't think anything of it. It's like, just don't worry about it. So you've warned what a weird thing. Your friends are forewarned.
Yeah, you're like, hey, you might hear some shit about me, but ignore it.
Babe,
Don't-
this Twitter person, I have to tell you, I think I've moved on to marker 4, and I just want to forewarn you, I'm feeling a little murdery. So I just wanted to let you know that, God forbid that I don't veer off the path, because I'm getting very close to the end, babe. I'm like almost to probing and breaching, babe. I'm like,
what they didn't
the next
ask is
marker.
like, do you have to start with one? What happens? So what happens if you're just
You skip grievance? Are you suggesting, madam, that you
and
jump
violent
right?
ideation, and you're just right at research and planning? Like, I
Well,
decided this day.
If you're at violent ideation, there has to be a target, doesn't there?
Right, but so this almost supports the defense that there was no fucking grievance. There was nothing she was festering over. She needs to be festering over something, right?
Well,
I don't know.
maybe their concept is that she was festering. She had a grievance over him controlling the purse strings so vehemently that she's
it
having to go.
spawned thoughts of murder.
She's going and forging refinance paperwork. All right. So from preparation, we then move to marker 4, which is probing and breaching. So that is the final surveillance and the testing of the
There's your
plan.
sandwich.
There's the sandwich. That one fits.
Right.
Hey, did you eat that delicious sandwich that I made you and left on your car seat? It's a good one. It's a good one. Make sure you eat it all. Every bite. It's delicious. And then you move to the attack.
Wow.
So that
is the stupidest thing I've ever heard.
Is your pathway to violence. That is science.
No way to get to a violent attack unless, of course, it is spurred by something that happens, in the moment. But there is no way to get to a pre-planned murder without going through these steps. You have to first get upset with somebody. I mean,
grievances.
But what about, how does this, so you can't apply this to like your typical serial killer who is just sick and targeting whoever, right?
Yep, no grievance.
You know, so
The serial killer skips the grievance stage.
right.
Marker number 1 skipped by almost all serial killers.
Right. Yeah.
Yeah, it's I'm not, god damn it, I can't find, where is our yes science? It's like, it's a great one.
See, it's
Where-
too late, babe. It's too
I
late.
know, I
You
know,
blew it. You
I know.
blew it.
Timing is everything.
You know what you didn't blow? Bringing me something to eat with my coffee. That was so
Got you, girl. Got you.
Mhm.
Got you. I know you love a little baked chive potato square thing. So if I can make you happy in such an easy way, you know I'm going to do it. All right, let's see. Yeah, I fucked it with the whole science thing. It's like it's vanished off the face of the earth.
Well, he was going to play it.
Are you sure?
Yes, I'm sure. It's the one that says, yes, science. It's
Right.
like, it's gone. It's
Or
gone.
you could have done the, I don't think I agree with your police work
I
there.
saw that one.
I'm not sure that I agree with you 100% on your police work there, Lou.
It's a good one. It's a good one.
Yep.
Yes.
You know, you can't come at us with all these late thoughts. You missed it. You fucked it. And
Yep,
you
I
got to live
know.
with it.
I know. All right. So before we go, since
Wait,
it was
we got
kind of the
G.
news of the day,
Oh,
I'm gonna, you know what we'll do? We're gonna play the oh, hi.
well, hello. That's such a pretty color on you, my love.
So
you.
I'm not sure
Yeah.
if you saw the email or the text from our daughter today that because
What?
of her stunning news, like fantastically beautiful news last night, that she got 100 on her
Well,
math
that's not
summative.
just because.
Well, I mean, I'm sure that played a part in it.
Okay.
I mean, your general mastery of math, I think, probably led to it, but
Because of her
her
brilliance.
teacher asked her if she wanted to be in advanced math as a freshman.
Advanced.
Advanced
Wow.
math.
Well, you know what
Did you
advanced
answer?
math would be great for?
No, advanced.
Someone who wants to,
Algebra.
Yeah, advanced algebra.
someone who wants to possibly be a doctor.
Yeah, I'm also asking to be in advanced bio.
Wow.
There
Are
you
you taking
go.
biology your first year?
Yeah.
You are?
And I'm doing Spanish. But
I'm
I have to do
very
Spanish.
I'm impressed with your brilliance. So
Yeah. I'm actually like hoping you shift to a whole science thing instead and like work on bringing humans to live on other planets. Like I could see you doing that. Cuz you used to be very interested in being an astronaut too.
I think you were interested in that
astronaut.
for me.
It was like she went from like veterinarian was the first thing for sure. Like she
Yeah.
definitely wanted to do something
Well,
with animals.
I think every kid did at one point.
Yeah,
I
that's
think
like
that's true. I
your
think that's
typical
somebody
sweet
just wants to
kid.
be with puppies all
A
day.
sweet, a kid that has that, sweet, lovable, nurturing
Who
side.
doesn't want to
like
hang with puppies every
Right.
day?
But her newest
How about
endeavor,
you?
a neonatal nurse
Doctor.
Thank
or
you.
doctor, one or the other.
I swung her
But
last
it's
night.
because
You know what?
Um,
Nurses actually do more
They
with
do.
but
the-
there's a
Nurses are the
pro.
real heroes.
There's a
Right.
pro and a con. The pro, you get way more money, but the con, you have to, for being a neonatal nurse, you only have to go to school for an extra 2 to 4 years. But neonatal doctor, you have to go for an extra 12 to 14.
Well, that
years.
includes
I
your
just-
residency. So your residency
Look,
is your
and
practice.
we can have the rest of this conversation off air, but I
Yep.
just think that Scarlett would enjoy the nurturing aspect of the nurse, the helping the patient, the helping the baby, more than just like the doctoring part of it. The nurse is really involved in that, in the whole process.
Actual care, like
Right,
the
and
care,
care.
the
Yeah, and they-
daily care.
They know a lot more than doctors. A lot.
Yeah,
more.
Doctors
see,
just float in and
She knows they don't make as much.
right. Brian knows.
Yeah.
Our chat
Well,
knows.
what?
All right. So this is going to be our last act. I love you. Give me a smooch.
I'll take one.
Our last act for the day. Go give mama kisses. Okay, so Reiner, as you know, was up. We're gonna watch it. It's 6 minutes. I think this includes the brief court appearance, and then I think it's going to include whatever Jackson may or may not have said outside of court. So
I
let's give
propose
this a listen.
1.25.
It's 6 minutes long, bro. But okay. All right. Let's go.
People versus Nick Reiner, case number 25 CJC F08098.
Good morning, Your Honor. Alan Jackson, on behalf of Mr. Reiner, who is present in court out of custody. I'm sorry, in custody.
Thank you.
Good morning, Your Honor. Habib Balian for the people.
Your Honor, we have a matter of housekeeping that I'd like to address in chambers in dealing with the 10 subpoenas that are outstanding. There are 10 current subpoenas that are outstanding. We would ask that body attachments be issued and held for each of the 10, specifically with subpoena number 4 on the list and subpoena number 10 on the list. Counsel for both of those individuals or those parties have appeared in court. They're here with us today. In addition, we have no principal objection to an extension of time for them to comply with the subpoena, but to maintain jurisdiction, we would ask that body attachments be issued.
I don't have a list. I'd like to get a copy, and I haven't seen the proof of service, but I assume the court.
Is it sped up? Because if so, slow it down.
Yeah, you told me to put 1.25, but it keeps. I'm starting to think this isn't today's. Because it's clipped. Like you can tell it's clipped.
Yeah,
You know what I
somebody.
mean?
I think somebody had already sped this up.
It's not that it's sped up, it's clipped. Like they're cutting from scene to scene. It was sped up, but what I'm also saying is that they've cut out dead air. But I want to double check and see.
All right. And then, take it back down to regular one because that was, whew. While you're doing that, I will thank Gigi, who says, love you guys. Happy New Year. Member for 2 months. I think Gigi of 9. Thank you for your continued support. Kaylee says Google searches will take her out too. And I put that comment up closer to when it was made, talking about Kouri Richins' Google searches, not only the walk the dog letter. So
Holy shit, Reuters was out there for 4 fucking hours before court.
Christy, is this who we sung happy birthday to? Glad you're doing this today. It's my birthday, enjoying the company since I'm home by myself till this evening.
Correct. Yeah, Chrissy's ride or die.
All right.
All right. So, I'm going to swap it out.
Okay. Well, we need for Curious actually, and wait, I can hear something.
Okay. Yeah, I'm playing that. I'll pause it.
Yeah. And Sheenan, I can't.
Where?
Sheenan
Donarovich.
Yes. What do they get? What do they need? Our new member.
Aw, family hug, Sheenan.
And
I think it's just
Curious.
Sheena. It's not Sheenan. It's Sheena.
Okay.
Yeah,
Sheena. Yeah, sorry. And Curious, actually. It was for both of them. And Under Your Scar, who's been a member for 2 months, but I recognize that name and maybe it's a returning member, but thank you.
Under Your Scar has been with us forever.
Yeah, right. I know off topic, but Jackson quit the defense for Reiner. Yes.
Oh, and Curious. Oh, family hug for you too. You get
We did
individual
put up
family hugs over here.
we did put up the Birdman. All right, so now let's do it. Go for
All
it.
right, let's see what we got here.
I mean, that doesn't look like court.
No, hold on. Patience, young Jedi.
Ready to.
See,
You put it back to 1, right?
yes, ma'am.
Thank you.
All right, what the fuck's going on? It's like frozen on the judge's face.
Do a bloop.
What the hell?
Refresh.
Okay.
There you go.
Oh my God. Reuters. Could be the same shit. Oh my. All right, there we go.
We're ready. So calling People versus Nick Reiner, case number 25 CJC F08098.
Good morning, Your Honor. Alan Jackson, on behalf of Mr. Reiner, who is present in court.
Looks like same shit.
In custody.
Thank you.
Good morning, Your Honor. Habib Balian for the people.
Your Honor, we have a matter of housekeeping that I'd like to address in chambers in dealing with the 10 subpoenas that are outstanding. There are 10 current subpoenas that are outstanding. We would ask that body attachments be issued and held for each of the 10, specifically with subpoena number 4 on the list and subpoena number 10 on the list. Counsel for both of those individuals or those parties have appeared in court. They're here with us today. We have no principal objection to an extension of time for them to comply with the subpoena, but to maintain jurisdiction, we would ask that body attachments be issued.
I don't have a list. I'd like to get a copy, and I haven't seen the proof of service, but I assume the court.
Did counsel for 4 and 10 present?
Yes, Your Honor. I'm not sure which number I am.
Number 10.
I'm counsel for number 10, and we do object to issue if that would resolve the court's concerns about retaining jurisdiction. However, we see no reason, given our appearance and the fact that we are here to issue a hold of non-detention.
And counsel for number 4?
In council number 10's statement, I don't see the necessity for issuing a body attachment. I too will stipulate the jurisdiction without necessarily waiving any objections we ultimately may make. But given my newness to the matter, I don't see the necessity of having a court order issued against an individual in this circumstance.
Fair enough. As to
Thank you, Your Honor, and just to be clear, we do also reserve all of our objections.
yes, and so, but as to the remaining numbers, that's 1, 2, 3, 5, 6, 7, and 8. Those the court will issue body attachment and hold it until the next court date.
And 9.
And 9.
There you go.
We have no objection to counsel's
Professor
recommendations. Both have graciously submitted to jurisdiction with regard to 4 and 10. We think that's appropriate.
Thank you. Once again, the court will issue and hold 3, 5, 6, 7, 8, and 9.
Thank you.
Until the next hearing date. And we'll
Does the
seal,
court have a list?
it does. The court will seal that list as well.
We've asked,
People have a copy, Your Honor?
we've asked that the court seal it specifically because it is ongoing defense investigator data or evidence that we recover or we get, our counsel on behalf of the
Shoppy.
gets. And that is discoverable. We'll comply with all, or counsel will comply with all discovery obligations at that time.
Can you address the council's request to provide a copy to the people?
That's the point. We think that should not be done because that would implicate ongoing investigative efforts by the defense. And it would compromise Mr. Reiner's right to a fair trial and his right to maintain his investigation with some level of confidence or confidentiality, I should say.
So at this time, the court will just seal it until the next court hearing date.
Hey.
And how else would you like to proceed?
Your Honor, at this time, I, on behalf of Watson Jackson and Quinn, and with Mr. Reiner's understanding and consent, would ask to withdraw as counsel's record based on the conversation that we've had in chambers and the explanation that we've provided to the court in chambers. We feel that we have no choice at this juncture but to withdraw as counsel and ask to be relieved. The Public Defender's Office has been notified. We've had conversations with them. They are here, they're staffed, they're ready to take over. My understanding is they're ready for the appointment immediately, forthwith.
Good morning, Your Honor. Kimberly Green from the Public Defender's Office. That is correct.
So the court will case, and so that firm is relieved as counsel of record, and the court appoints the Public Defender's Office to represent Mr. Reiner.
Thank you, Your Honor.
Current counsel turnover, any items that they were.
We will absolutely comply with that. We've already begun the issue has been met.
Your Honor, there's a protective order issued by the court in place regarding the handling of discovery order that's remaining in place for now. And we'll serve a copy of that on the Public Defender's Office along with the discovery we provide.
Yes, the court will order that order.
Me from giving Mr. Bailey raises a very sage point.
That is a hellish looking courtroom.
Yeah.
Like they still have up all the COVID shit with all those fucking plastic screens and shit. Holy shit, dude.
Yeah. So I
That's
just
like
want
a cattle call courtroom right there. You could tell.
Yeah. So I just want to say while you have it paused. So, and I, it's significant that what Alan Jackson wanted to do is dot some I's and cross some T's and get his client, get shit set and his client in the best position before he withdraw. Get the issues that should be addressed right then and there addressed and then withdraw afterwards. So, that was.
Yeah. And we can speculate. Like I had tweeted earlier, we have no idea why Jackson dipped. I tend to think it was Mr. Green, that critical witness that probably didn't show up, because when you when something happens suddenly and people are scrambling trying to find a lawyer, and when you're talking about a family like the Reiners and this thing happens with Nick, and you've got family probably calling who's the biggest big shot in all of LA. Well, that's Alan Jackson. They put the call into Workman. They get Alan on the phone. He's like, and they don't really get into the money side of it at length. There's probably like, okay, well, like I'm going to need an initial retainer of this. When we see what we're up against, we'll revisit this. And then, that gives the family time. They're getting more information. So the reality is, and the fact that they pivoted to the PD, which
Right.
doesn't mean that they won't eventually pony up money for another lawyer, but the fact that they did that kind of to me indicates that it probably was money that they couldn't come up with, or they were not willing to come up. They definitely could come up with the money, but weren't willing to come up with the money to retain Alan Jackson and his firm. We'll never know.
Right.
I'm assuming, but
I think you're right, because if it was, hey, we can't afford your fee, we're looking into other attorneys, then Alan Jackson would probably just say, Your Honor, it's likely I'm going to be withdrawing. They're looking for other counsel. So let's set another status date, and he would have kind of not abruptly left and appointed the public defender. I think, like you said, because the public defender is coming in right now, that's what it's about at this point in time. And it doesn't seem that they are.
Carol thinks it's a conflict. Can you expand on that?
If it's a conflict, that could explain why they're doing it so abruptly.
Yeah, that
But
could be the other thing. And do you have some intel that we don't know in terms of a potential conflict here?
Because usually a firm like his is going to do a conflict check before they even get
Well, I mean, like the first appearance was like in very short notice. So, I mean, he may have entered his like, I think it was by the next day, like they were in court. So, and he was in court, and I'm sure he filed his appearance
in.
at
All
that
right, so
point.
say keep going and listen to the press conference, and we'll learn some more. So,
Okay, I don't think we learned much more.
I'm under a protective order not to provide our discovery to anybody else. That would text providing the information only to Ms. Green in her office. Then I can be in full compliance with the protective order.
Anything to the people, any response to that request?
No problem. I believe the protective order spells out that it covers Mr. Jackson's firm as well as any successor counsel.
Thank you.
So you can provide everything to the screen.
Thank you.
Thank you. Anything further? Back on the record in People versus Nick Reiner, case number 25 CJC F08098.
Good morning, Kimberly Green, Eric Richins, Public Defender's Office, on behalf of Mr. Reiner, who again is present.
Thank you.
Good morning, Your Honor. Khabib Valian, representing the people of the state of California.
Thank you.
Your Honor, with the court's permission, we'd ask to put over the arraignment one last time to February 23rd, if that date is appropriate.
That date is fine, of course.
Thank you, and I will work with Ms. Green to get her discovery prior to that date.
I'll take any waiver. Entitled, you have a constitutional statutory right to a speedy arraignment. Your counsel, Ms. Green from the Public Defender's Office, is requesting that your arraignment be continued to February
What did you just say about speedy?
23rd, 2026. In this department, you waive your right to today so that your matter may be continued.
Want me to rewind it?
No, I get it.
2026 for arraignment.
Pause it so I can explain why. So I think what the judge just said there was, whenever the defense asks for a continuance, so look, I'm going to continue the arraignment, that does not count against the speedy trial clock. So what she's saying is, that this time that the defense just asked for a continuance of, that doesn't, that doesn't count against your speedy. You're waiving that time frame as it relates to any speedy. So go ahead. Sorry, babe.
Okay.
Does counsel join that waiver?
I do.
The court finds that the defendant has made a knowing and intelligent waiver of his right to a speedy arraignment, and that his counsel of record joins in that waiver. Matters set for arraignment in this department, February 23rd, 2026. Bail remains at no bail. Anything further?
No, Your Honor.
Okay, thank you.
Thank you.
Thank you.
That's the end of that one. So I'll loop it.
Bloop, bloop.
The vultures.
Bloop, 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 bloop.
Slider situation. Sliding.
Yep. There you go.
Wait, what do you mean?
Oh, I thought I saw someone at the microphone. Sorry.
No. Okay.
Okay.
Here we go.
Yeah, right here, right here. Good morning. As you know, my name is Alan Jackson. This morning, I had to withdraw as Nick Reiner's counsel. Circumstances beyond our control, but more importantly, circumstances beyond Nick's control.
Okay. So you're
Have
right.
dictated that, sadly, it's made it impossible for us to continue our representation of Nick. I'm legally and I'm ethically prohibited from explaining all the reasons why. I know that's a question on everybody's mind. We expect the public defender to step in. They've already been appointed and very capably protect Nick Reiner's interests as he moves forward through the system. But be clear, be very, very clear about this. My team and I remain deeply, deeply committed to Nick Reiner and to his best interests. In fact, we know, we're not just convinced, we know that the legal process will reveal the true facts of the circumstances surrounding this case, Nick's case. You know, a lot's been printed of late, over the last 3 weeks. A lot has been printed about Nick, printed about his family, printed about the circumstances, speculation is in print. On December 15th, in the early morning hours, I was in New York at the time, and I got a call. Me and my team, we dropped everything. And for the last 3 weeks, we have devoted literally every waking hour to protecting Nick and his interests. We've investigated this matter top to bottom, back to front. What we've learned, and you can take this to the bank, is that pursuant to the laws of this state, pursuant to the law in California, Nick Reiner is not guilty of murder. Print
Not
that.
his lawyer. Print that.
Print that. We wish him the very, very best moving forward. And that's all I have today.
Alan, anything you want us to know about Nick Reiner?
The one guy was the dude handling, it wasn't Mr. Bates. I think Master Bates was the first trial, but the other guy, who was the second guy that was bringing all the shit up on the screens?
I forget.
Tiny desk guy. That was the guy.
What we should have done
his left shoulder
is created a new live for this and put everybody over, because this would have been a great its own live. Maybe we should do it later.
Yeah, maybe.
It's
I can see why people might think that it might be a conflict, but if they can't come up with the money, that's the same response that you're giving. Like he's never getting up there saying anything about money ever.
Right.
And the fact of the matter is that PD has been appointed. Yeah, Wolf. Or Woke. Yeah, one of the two. So I don't know. I mean, we don't know. There's really no use speculating. Like a conflict seems like they would have known prior to 3 weeks.
But like you said, if it could have come up with something that they didn't anticipate. I don't know what.
Every lawyer in LA is not conflicted out. You know, why would a family with that type of means?
Well, but
and
like
again,
you said, if it's a conflict and they realized it, but they could have stayed on and just not done certain things. Who knows? Who knows what it is?
And plus, I mean, just the portion of it that deals with the fact that the PD is, and this is no slight on the public defender's office. You can have incredibly competent, fabulous lawyers.
Typically, when you get to like the person who heads the murder, the homicide division.
My father was
that's
a
gonna be
phenomenal attorney
right.
when he was in the public defender's office.
Right.
It's all that matter of time. That it's the difference is the time that can be dedicated to the case is vastly different from private counsel to public defender. That's what you're paying for. You're paying for a lawyer that has infinite amounts of time above and beyond what the public defender will be able to devote to the case typically.
But
I
I
mean,
think
a case like this, they might,
right.
they might carve out, a
Exactly.
couple of PDs there, but
And they reduce their load so they
all
can
I'm
focus on
saying,
that.
babe, is when you got the Reiner family that's incredibly wealthy and they're sticking with the PD for Nick, it's telling. Just is. Like, I mean, you could read whatever you want from it,
Right.
but
Well, maybe, and like you said, maybe they will find somebody else.
maybe. So
He
yeah,
is
I mean,
not
they're
guilty of murder. Print
yeah, I mean,
that.
by reason of insanity. That's
Because he said under the laws of this state,
right.
that seems like not guilty by reason of
It
insanity.
has to be a reason, but like we know that he did it.
But
Like,
let's see. This is why this needs to be another live. We'll have to do a whole nother live on this because now I want to look up the statute. Do they which rule do they use and da 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 da. I think we do if you've already watched this, don't join. We're going to do a separate live on this. We can convert it into a podcast. It'll be under an hour, so it'll be perfect.
yeah. So a public defender's office, if the county's big enough to have a dedicated public defender's office, I mean, all of the indigent defendants that have that right to be appointed counsel, they're appointed counsel. So, like public defenders, you're going to have, it's like any hierarchy. You're going to have the top dog and then everybody below them. I mean, they have very, very full caseloads.
But in a case like this, they will, they typically, I don't know, I've never worked the public defenders, but my understanding is that they would, reduce their load so that they had more time to
as
concentrate
much
on
as they can.
Right. Well, especially the head, I mean, the department head of the homicide division, that person doesn't have a whole shit ton of cases, you know? So,
I mean, maybe. I mean, we're talking about LA. So
that's true.
they might.
That's true.
They might have a shit ton of cases. So,
all right.
yeah. I mean,
people.
typically the public defender does not represent people that have, like, Nick is indigent. Like, so when the judge is looking at Nick and says, okay, Nick Reiner himself, without, like Ali was saying much earlier in this live, in terms of his access to the family's money because of what he's accused of, it's probably not available to him. So in that sense, when they're looking at Nick's assets, they're going to find that he's he's indigent and therefore he is eligible to be appointed a public defender. So, I mean, that's where it's at with him, because, a lot of times when Allie and I get clients and our client is, being held and they're not out and we're dealing with the family and, it's the family, at the end of the day, it's still the client that needs to sign off on retaining us, not the family. The family may provide the money, but make no bones about it, it's the defendant that hires you, even if they're not the one supplying the money. So, interesting turn of events.
Yep.
For sure.
All right. Thank the people.
All right. Hold on. I'm not ready. I'm not
Oh.
ready. So, okay. So we know tomorrow, no Richins, which is perfect, because tomorrow, I think I'm thinking about tonight instead of, well, unless you want to pivot to this, I want to do the Richard Allen, but the live where it's regarding Turco, the professor. I think it'll be an interesting live. I want to hear this Holman interview. I want to compare it to.
I don't even know what you're talking about.
Well, what do you mean?
What Holman interview are you comparing what to? What are you talking about?
So you remember the Purdue professor,
Yeah.
right? Okay, so Holman, this was recently released, had an interview with him in 2023 where he's saying some things that are clearly in contravention of what the prosecution was saying at various hearings.
That just somehow was discovered?
I don't know.
And how do we have? Well, whatever. We're gonna.
Well, Sleuthy sent it to me, but I know Andy had it. Like she was the first place I saw it pop up. But Sleuthy sent me his deposition, which Sleuthy's upset that they even did the DEP because of what he said in this investigation, in terms of Holman speaking to him, which again, you have McClellan standing in open court calling, like flat out calling, the defense attorneys for Richard Allen liars. And it turns
Well,
out
I think we do that. We could also do this so long as we're ready with another live setup, and then we can just switch everybody from the one to the other. I mean, I've seen it on Court TV and Law and Crime that they've got multiple lives scheduled
For what?
the same day,
For
just
whom?
different times.
For who?
I'm just saying in general, like we could have
Oh,
right.
oh, yeah.
We could have
All
both
right, but
lives scheduled and then switch.
tomorrow, what I want to do is I want to start the Zach Adams trial.
Well, but then as long as there's nothing else the next day, like I don't want to break it up like we did something else and we didn't get back to it again until like weeks later.
Well, Tracy will let us know. Like she puts out a full docket of everything that's coming out on the daily. So
All right.
it's Seeking Justice. You should be following Seekers for Justice on Twitter. That is Tracy's Seeking Justice, and obviously Seeking Justice Discord channel. That's where you get all the news that's fit to print, all the docs that you could ever want. Those two things are definitely places that you should be following if you're wanting to know what's going on all over courts across this country.
Yeah, and I just want to say we have, at least right now, and I think we just had more than this, we have 1,197 people and 466 likes. So minimize the chat, y'all. Just hit that thumbs up. Just hit that thumbs up. And if you haven't
a shit ton of
subscribed,
them are on Twitter.
hey, come on, Twitter people. Go to
Yeah.
YouTube and click like.
For real. For real.
Please.
Do the right thing. Do the right
Yeah.
thing, Twitters.
And subscribe. It's free.
Yeah, subscribing. All right. So mods, thank you so very much for all your work. Tracy, thank you in particular for everything that you do on a daily basis. We adore you so very much. And go sub to both the Discord and the Twitter account. Seekers for Justice. That's at Seekers for Justice. That's Twitter. And then the Discord, which we've been dropping the link here. They're phenomenal. Tracy's on top of all of it, and she's amazing. And thank you, mods, for everything that you do on a daily basis. We love you. It was great to see Brooklyn back in here. It had been a hot minute. I was messaging her. I'm like, where are you? Where are you? So thank you guys for everything. Thank you for your generosity today. For those who were kind enough to send us some dough, we always love the donos. Please remember to like, share, and subscribe. It's so important. Hit that subscribe. It's free. If you like our content, if you love hearing Allie's fantastic legal analysis, subscribe to it, because that way you never miss it. And we love our community so very much because you guys make it up. And if you guys didn't exist, I would literally be just an old man
Sitting around talking to his wife.